good Saturday late Saturday morning, early Saturday afternoon, wherever you are in this great country of ours. Welcome once again to Bethea'S Byte Reloaded. So I'm so glad to have you here, Ernest Bethea, the last outlaw in my house, and I'm starting a tad bit earlier than normal, but I want to give you a chance to come in, get settled because as always we've got a lot to cover. So, like I said, come on in, get settled in, tell your friends that the drama-free true crime destination is off and running, and we got a great deal to cover, starting in missing persons like we always do. So I'm gonna give you the screen for that right now, and I'm gonna go ahead and scroll up to the top for the name. There we go. All right. This is Matthew Tyler Henry. All right, take a note of everything you're seeing here. On the far left is a, a photo of him taken back in 2014. On the near left side is the tattoo on his chest. Left arm tattoo on the near right side, and on the far right, a full-on arm sleeve. Now, here's all the information I have. Matthew Tyler Henry, also goes by Matthew T. Henry. He's been missing since April 15th of 2018 out of Dunlap, Tennessee. Give me 1 second. Stands between 5 feet 8, 5 feet 9, weighs between 160 and 180 pounds, and I just showed you the tattoos on his chest, upper left arm, and entire right arm. He was last seen on April 15, 2018 in Dunlap, Tennessee, reported missing on April 27th, 2018, and has not been seen or heard from since. Matthews been previously resided in Dunlap, Tennessee. He is known to have frequented Marion County, Bledsoe County, White County, Van Buren County, and Hamilton County in Tennessee. He has also frequented Dalton, Atlanta, and Albany, Georgia. Alright guys, this is where you come in. Anybody in all those areas, if you have any information or you have seen Matthew Tyler Henry, please, whatever you do, do not hesitate. Call 911. Call your local FBI field office. Call the FBI toll-free tip line, which is coming up on your screen now. 1-800 call FBI. 1-800-225-5324, or you can send your tip in anonymously at tips.fbi.gov. Every bit of information helps, and it brings us a step closer to bringing Matthew home safe and sound. And I'm not just saying this just for Matthew's sake. That we have plenty of missing persons cases out there just like this, and any information you give is a step closer to bringing that person home safe and sound. You're asked to basically share this and other messages just like this, to pass along to someone who may have valuable information. As always, I want you to remember now. If you see something, say something, but this time, you see something, say something. That way we can actually do something. All right. Now let's go ahead and get ourselves prepared. Yeah. because, like I said, we've got a lot to run through this week. Let's start with this story to kick off everything. We've heard about the case. We've heard about the two missing women, a preacher's wife and the preacher's wife and her friend, right? Well, the information that we received is that they go by it's a group of people who call themselves God's Misfits. God's Misfits. So, I'm gonna go ahead and turn this over to Court TV's Michael Ayala, who has a little bit of information on God's Misfits and how they factored in to the missing persons case of Veronica Butler and Jillian Kelly.
All right, we're going to pause testimony here to bring you this update in the case of two missing moms from Oklahoma.
Police say they are still waiting for the bodies of the two women to officially be identified, but they are certain that they are the remains of Veronica Butler and Jillian Kelly. Now, the two women had been missing since the end of March. Their car was found in a rural area near the Kansas state line. And investigators say Kelly was married to a preacher and that she was accompanying Butler to Oklahoma to pick up Butler's children from a birthday party. Now, officials say the women were targeted.
This case did not end the way we had hoped. It has certainly been a tragedy for everybody involved.
We felt this wasn't a random deal, all right? We felt that with some of the information coming in that it was more targeted, and we started to look in those areas that we were pointed to.
Police arrested 4 people in connection with the murders. One of the suspects, 54-year-old Tiffany Adams, is the grandmother of Butler's children. Investigators also say the motive may have been a custody dispute. The suspects are all part of an anti-government group calling themselves God's Misfits, and all are being held without bond ahead of court appearances scheduled for Wednesday. Of course, we will keep you updated on that.
God's Misfits. In just a matter of seconds, I'm gonna give you the identities of all 4 of those of that group. Well, Michael Ayala mentioned 54-year-old Tiffany Adams. Adams, the children's grandmother. The 3 others who are involved in that group is 43-year-old Tad Burt Collum, 50-year-old Cole Earl Twombly, and his wife, 44-year-old Cora Twombly. They're all charged with first-degree murder, kidnapping, and conspiracy to commit murder in the first degree. And like Michael Ayala said, we're gonna keep you updated on this case. But in fact, I do have an update regarding this as well that I can give to you right now, if I can find what I'm looking for. Yes. Here we go. All right. So we got the initial update from Michael Ayala. Now I'm gonna take myself off the screen and put you in the capable hands of my main man, 50 Grand, Vinny.
Welcome back. Time to reveal something else you need to know tonight. Let's take a look at our big board, and there you have 2 victims, 2 moms, Veronica Butler and Jillian Kelly. Both murdered. It was brutal. It was gruesome. 4 suspects have been charged, and we have a lot more information tonight from Sydney Batzleff from KFDA.
Do you have any remorse? Did you do it?
Murder them.
Do you have anything to say to the children whose mothers are murdered?
Why? One by one, each suspect was led inside the Texas County Courthouse, wearing handcuffs, leg shackles, and a bulletproof vest, showing their face for the first time since the brutal killings to Veronica Butler and Jillian Kelly's families.
Just no justice is served.
All 4 suspects are facing charges that include 2 counts of murder, 2 counts of kidnapping, and 1 count of conspiracy to commit murder. The prosecutors said the suspects lured Butler and Kelly to Highway 95 and Road L and took them to another location where they died from injuries.
How can you hate somebody so much that you want to kill them? How can you hate the mother of your grandchildren so much that you want to end her life? That was not fair to her. That's not fair to our family.
It's not fair to Jillian's family either.
Inside the courtroom that isn't allowing cameras, Butler's father was seen lunging toward all 4 suspects, shouting profanities. The suspects showed little emotion. From my seat in the courtroom, I saw Cora Twombly shake her head no as charges were read aloud. Prosecutors say the death penalty is a possibility for all suspects if convicted. Even for law enforcement, this case is hitting home.
We're not robots. We are human beings, and we have emotions. So I'm getting emotional.
Tough case. Another custody battle turned deadly.
Honestly, who would be as ugly, as hateful to end the life of your and I'm using just in Tiffany Adams's case. Why would you be hateful enough to end the life of your granddaughter's mother? Oh my gosh! Oh, this is the way we're starting it off, ladies and gentlemen. Like it was said in the report. If they go to court and they're convicted, Adams, Callum, and the Twombleys could end up facing the death penalty. They're currently behind bars under no bond. Next up, just when we thought we would have heard the end of anything associated with Ruby Franke or Jodi Hildebrand, we get this update. Ruby's ex is targeting Jodi Hildebrand in a lawsuit for abuse. Now, I know I've got my commentary on this, but I will save my commentary for the end of this. Right now, I'm gonna let you guys hear this from hear what the deal is from Julie Grant.
Welcome back. Now for what's trending in true crime. The husband of convicted child abuser Ruby Franke is going after her co-defendant. Kevin Franke is suing Jody Hildebrandt, who was also convicted of abusing two of the couple's 4 children. He's accusing Jody Hildebrandt of emotional distress and negligence towards him and to his children. You'll recall that Franke's son escaped Hildebrandt's house and went to a neighbor for help. At the time, Kevin Franke says he didn't know what was happening with his children.
They're not at your home in Springville. And I'm not trying to trip you up. I can see you're hesitant to talk to me. I understand that.
Well, where I live, no,
Yeah.
I haven't seen it for over a year. Like I said, I know nothing that's going on in their lives or anything going on. We've communicated maybe 4 times in 2023 since January.
So are you aware of how she disciplines the kids or how she handles the kids with behavioral issues or anything like that?
No.
Now, you'll recall Ruby Franke and Jody Hildebrandt, they were both sentenced. They are serving 4 consecutive sentences of 15 years in prison because they pleaded guilty to felony child abuse. But between these 2 women was the non-mother, Jody Hildebrandt, the mastermind behind everything. We have a rock star panel to break all this down today. Our guest, criminal defense attorney and Professor Dom Larsick, is still with us. And joining us now, law enforcement and litigation expert Sonny Slaughter. Also retired criminal defense attorney Kirk Nurmi is with us. Thank you all for being on this Monday morning. Our question today for this topic that's trending in true crime is, was Jody the mastermind behind everything? Sonny, let me start with you.
I think she was the mastermind, but I also think the mother has a lot of culpability. You know, she created this ruse. She kept the children away from the father, but Jody clearly had some type of influence over her to make her harm her own children. I mean, it's just unconscionable what happened to these children. And I'm not sure where the father was throughout this. He said he didn't see the kids for an entire year, but what efforts did he make to actually see them in person?
He says that Jody Hildebrandt came in and manipulated his wife into leaving them, divorcing him, and taking the kids and not telling him where the kids were. Kirk Nurmi, is she the mastermind? Does he have a stance in civil court to get money damages from Jody Hildebrandt?
I think he has a shot. I mean, he obviously can't sue his wife. It's not going to be a financial benefit to him to do that. So he's going to focus on Jody. One of the things that's interesting about this case, I think, is that we're going to see behind the scenes, like there's a lot of speculation that maybe Kevin knew what was going on, but, you know, so she will be able to attack him, say he's partially liable as well. But what's really going to be fascinating about this case is I think we're going to get a chance to see, if it goes to trial, how these women both, and I don't know that anyone in particular was riding the bus, but I think they got intoxicated by this fortune and fame they were getting off YouTube, and probably reinforced to some degree. The more subscribers they had, the more justified they felt like how they were treating their children behind the scenes, because obviously people were responding to it. So I think this lawsuit is going to be really give us a behind the scenes look of what was going on. How involved was Kevin, and what were these women really up to? Were they really intoxicated by this fame and fortune?
You make a good point, Kirk, that it could be that the defense can argue it's not Jody herself who was able to lure away or cause all of these problems in this marriage, but could it just be fame and fortune? Would you be able to go after, let's say, Don, a homewrecker for breaking up your family? He's making the argument of intentional infliction of emotional distress and negligent infliction of emotional distress. Your thoughts on whether Jody was the mastermind?
You know, it sure feels like that. And whether she was the mastermind and she was 90% responsible or just a willing participant and 55% responsible. She's the one with the deep pockets. And the behavior here is so outrageous. Even if she's found to be, 50 or 60% responsible, I think the verdict could potentially be huge because of what these kids went through, what she did, her deliberateness. She's pled guilty, so there's no real issue about her culpability and her fault. So I think, going after her makes sense. It's smart. And you don't necessarily have to prove she's the mastermind. You just have to prove how reprehensible her behavior was, and she's responsible for these kids' abuse.
Great point that the criminal case has been completed before the civil. We see different timing sometimes, but with that culpability already in place, it's a lot easier because the burden is a lot easier in a civil case.
Step up and answer the question that was posed. Was Jody Hildebrand the mastermind as far as the way everything went down? I can say yes, she was the mastermind, but then again, Ruby's hands weren't necessarily clean either. Remember, long before there was a Jody Hildebrand, Ruby Frankie had the 8 Passengers YouTube page. Long before there was a Jody Hildebrand, Ruby had so many subscribers and raking in lots of money because everybody just followed along with everything she was going with as far as how to parent their children and offering up the same advice. And a lot of what Ruby did must have intrigued Jody, so they ended up linking up to continue doing the same thing under Jody's banner. So as far as I'm concerned, yes and no. Jody may have had her hand in it, but I believe in the saying that one hand washes the other. And in that case, Jody Hildebrand was washing Ruby Frankie's, and Ruby Frankie was washing Jody Hildebrand's hands. Neither one of them are clean. And as far as Kevin Frankie, Ruby Frankie's ex, where was he? That's the question. Sure, he can sue Jody Hildebrand all he wants to. But the bottom line question is, where was he when his children were being abused, both by Jody and his ex-wife Ruby? So, as far as I'm concerned, Kevin Frankie isn't all that clean in this either. But that's my take on it. You can leave me a note in the comments section. You can drop a note in the community section regarding that. And I would love to hear your take on it. The question is Jody Hildebrand the mastermind in the in this whole mess with her, Ruby Frankie and those kids? I'm just glad that the kids are safe and away from those monsters. Okay, moving right along, the Rust movie shooting trial. And this one, let's just say, for Hannah Gutierrez, it's over. But for the man behind the whole movie, Alec Baldwin, it's not even close to starting yet. Right now, I'm gonna take you to the sentencing of Hannah Gutierrez for her part in the shooting.
All right, so I've made some notes along the way, so if I refer to the notes and I'm not looking at tables, it's because I'm reading. First of all, thank you for your presentations. Thank the friends and family of Helena for presenting their memories and their losses of Helena. There are really three choices for sentencing before me. What the defense wants is a conditional discharge. This means straight probation, unless Ms. Gutierrez comes back on a probation violation. She won't have a felony conviction on her record, so she can continue to possess firearms. Again, unless she comes back on a probation violation and receives the imposition of the probated sentence. The second one has not been offered by counsel, but I've certainly thought of it, and it's to continue her in the Santa Fe County Detention Center. That would be for 12 months. That's all she's allowed to stay at the detention center. And then put her on probation for the rest of the time. She's facing 18 months. She's got pre-sentence confinement for about a month or so. In this scenario, she won't experience prison. She will be a convicted felon. She cannot carry a firearm under federal law and for a specific time under New Mexico law. And then there's prison. And the state has proposed at 85% of the time sentenced to incarceration based on the serious violent offense statute. For all the fanfare and pundits and finger pointing that has been going on for over 2 years, we were able to seat a jury of her peers who confirmed that they could listen to the evidence received in court and determine the facts and apply the law. They found Ms. Gutierrez guilty of involuntary manslaughter. What were some of the poignant facts that came out during the trial? In her police interview, she proudly owned her position as armorer. On October 21st, 2021, chaos ended after the film crew walked off. Ms. Hutchins and others were trying to rig, if you will, how they were going to keep filming. And what was the defendant doing while waiting? She was loading Alec Baldwin's gun. Did she have enough time to load the weapon safely? Plenty. Did she load the weapon? Yes. With dummies and a live round. Did she check what she was loading? No. Why? Well, in her own words, most recently, in her jailhouse calls, she didn't need to be shaking the dummies all the time. Did she check after that? No. And while you've heard her concerns about how she'll never work again as an armorer leading up to the trial, have her concerns changed? No. Here's what she says. This whole thing has been a character attack on her. Just recently, in her allocution, I'm not a monster. And what did, where is it? They talk about how much of on the phone, she and another are talking about how much of Hannah's life that, they could take up, and that this is messing up her modeling career. This is while she's incarcerated, waiting for a sentence. And what does she say about the death of Helena? Hannah is dismissive of the judge talking about someone dying as a result of her actions. Hannah says she's looking at 13 months, which is ridiculous over what happened. Hannah says that people have accidents and people die. It's an unfortunate part of life, but it doesn't mean she should be in jail. a conditional discharge is not appropriate. And the second option of leaving you in the detention center would be giving you a pass you do not deserve. I did not hear you take accountability in your allocution. You said you were sorry. You were sorry, but not you were sorry for what you did. You were sorry for it and hope they can find peace. It was your attorney that had to tell the court that you were remorseful. The word remorse, a deep regret coming from a sense of guilt for past wrongs. That's not you. You're hereby sentenced as follows. Stand. I am sentencing you to 18 months of incarceration at a New Mexico Women's Correctional Facility. I find that what you did constitutes a serious violent offense. It was committed in a physically violent manner, a fatal gunshot done with your recklessness in the face of knowledge that your acts were reasonably likely to result in serious harm. You were the armorer, the one that stood between a safe weapon and a weapon that could kill someone. You alone turned a safe weapon into a lethal weapon. But for you, Miss Hutchins would be alive, a husband would have his partner, and a little boy would have his mother. Please take her. I'm going to ask the deputies to watch how the courtroom gets cleared. Please do an order of remand to the transport order to the Department of Corrections and the judgment and sentence.
Yes, Your Honor.
All right. We are in recess.
All rise.
Friends, I don't know about you, but I have heard sentences where the judge reads the defendant like an open book. This judge read Hannah Gutierrez just like a wide open book before sentencing her to 18 months. Designated her conviction as a violent offense. And her sentence can only be reduced by only 4 days a month as compared to a nonviolent offense in which she could have potentially received a deduction of up to 30 days a month. Ooh, boy. But like I said, though, for Hannah Gutierrez, she's done. It's a wrap. But we still have Alec Baldwin to deal with, and that's coming in July. He was the producer. He was the director. How much fault does that lie in with him? We shall wait and see. And trust me, this is something that we all are dying to hear about. Next up, we're gonna go to everything that went down on Tuesday, starting with the Karen Reed trial. Now, if you hear anything in the back, that's my wife preparing and promoting her coffee. It works. But anyway, Karen Reed's trial is either preparing to begin or is already underway. Jury selection underway. No, correction. Karen Reed's jury is seated. Karen Reed's jury is seated. She is charged with the death of her police officer boyfriend in Boston, John O'Keefe. he was found dead in the snow outside the home of a fellow officer in January 2022. Prosecutors accused Reed of hitting O'Keefe with her car while dropping him off at a party at the residence and leaving him to die. Her attorneys are alleging a sloppy investigation and a cover-up. Karen Reed is charged with second-degree murder, motor vehicle manslaughter while driving under the influence, and leaving the scene of a collision causing injury or death. If convicted, she could face life in prison. Now, I'm reading all that, and I was trying to get this out for all the for the entire contingent of Free Karen Reed, Free Karen Reed, Free Karen Reed. Let me do this the best way I know how. Ladies and gentlemen, my name is Ernest Bethea, aka The Last Outlaw, and I, the host of Bethea'S Byte Reloaded, have no skin in this trial of Karen Reed. So, I'm not pro Karen Reed, I'm not anti Karen Reed, I am, as my wife would say, I'm Switzerland. Is that how you put it, honey? I'm Switzerland. I am as neutral gets. I am here to report on all things legal in Karen Reed's case. Thank you. And that's the bottom line. Oh my gosh. I do not want to get bombarded by the Free Karen Reed people over, hey, you're taking sides. No. I'm reporting by the information I got. Anyway, let's see. Jury selection began Tuesday the 16th, and Court TV is live streaming the trial gavel to gavel, beginning with opening statements. And ladies and gentlemen, that is one for especially for all those who are still chanting Free Karen Reed, Free Karen Reed. You're gonna want to pay attention to everything. Everything. That's why it's called evidence. Whew. Next up, we're going to go to Atlantic City, New Jersey, where the mayor and his wife, who also serves as the superintendent of the school district, are facing charges after investigators say they abused their daughter, with one incident leaving the victim unconscious. The article says that Marty and LaQuetta Small are facing a list of charges including endangering the welfare of a child, simple assault, and aggravated assault for what prosecutors say were multiple occasions of abuse in December 2023 and January 2024. Prosecutors listed a number of disturbing incidents that led to the charges. Including one where Marty allegedly used a broom to beat his teenage daughter in the head, causing her to lose consciousness. Quote, another incident alleged that Marty Small Sr., during an argument with his daughter, continuously threatened to hurt her by earth slamming her down the stairs, grabbing her head and throwing her to the ground, and smacking the weave out of her head. End quote. Investigators say that on one occasion, Marty punched his daughter's legs repeatedly, causing bruising. LaQuetta is accused of punching her daughter in the chest and mouth, as well as dragging her daughter by the hair and hitting her with a belt. Before I can even continue with this article, I'll say this and end my commentary on it. There is a fine line between physical discipline and straight up abuse. And from everything that I've read so far, and this is this man is supposed to be the mayor of Atlantic City, New Jersey. That's crossing the line. There's physical punishment, physical discipline, and then there's straight up abuse. And Mr. Mayor, you crossed the line. Whatever you get hit with, you deserve every little bit of it. I'm also of the belief of that old adage, let the punishment fit the crime. Let's see exactly how you and your wife would like it getting beat the same way you beat your daughter. The charges were filed 2 weeks after police served 5 search warrants at the family's home. Days after the search, the mayor addressed the media saying, quote, "Though she has a doctorate and I have a master's degree, there's no book, no course that we took in college to show you how to be a parent, and more importantly, how to deal with the struggles of raising teenagers." I will say my commentary on that in just a minute. An affidavit obtained by the Associated Press revealed that several incidents of alleged abuse were recorded, apparently without the parents' knowledge. Prosecutors reference an incident allegedly witnessed by the teenager's grandmother, who was quoted as saying, "A little punch in the eye ain't gonna stop her." Marty was named mayor of Atlantic City in 2019 and was sworn in for a 4-year term in 2022 after winning 70% of the vote. Laquetta, who has worked in the Atlantic City Public School District since 2003, was appointed to a 4.5-year term as superintendent of the district on January 1st, 2022. Court TV reached out to the school district for comment. In a statement to Court TV, Marty's attorney characterized the charges as attempting to second-guess parental decisions and specified that the complaints were issued on summonses, meaning that the couple was not arrested and no bail was set. Mayor Marty Small remains the mayor in the city of Atlantic City and will continue to faithfully perform his duties as mayor. And he and his wife Laquetta and their 2 children remain a close, loving, and intact family. Mayor Small and Superintendent Laquetta Small are completely innocent of any wrongdoing and will ultimately be vindicated. Yeah. And 50 cents will buy me a cup of coffee over at Starbucks. And my wife getting speaking of coffee, my wife prepping hers right now. Now she gets a kick out of every time I use the old Starbucks bit. Let me go back and say this. If everything I've read was legit and true, Mayor Marty Small and Superintendent Laquetta Small, yes, I'm calling them out by their titles, they crossed the line. There is no reason why a child needed to be, and I'm using air quotes for this, There's no reason why a child should have been disciplined in that manner. I don't care if she's 3 or 13. That makes no sense at all whatsoever. Sorry. I hope they get everything that's coming to them. I'm sorry, guys. I'm a bit distracted because my wife is promoting her coffee. But now, hey, she's doing her thing. I give her all the credit in the world. Right now, I'm taking you to this story regarding Scott Peterson. He's back in court in a bid for a brand new trial. Is he truly convicted for the murder of Lacey Peterson? Will Scott Peterson get a new trial? Let's jump right into this article.
On the record, the matter of People versus Scott Lee Peterson, case number SC 055500A. If counsel would like to state their appearances, starting with counsel for Mr. Peterson.
Good morning, Your Honor. Paula Mitchell, Los Angeles Innocence Project for Scott Peterson.
Thank you. Good morning. And counsel for the people.
Good morning, Your Honor. Attorney Vasquez, District Attorney's Office, Stanislaus County for the people.
Good morning.
David Flagger, District Attorney's Office, Stanislaus County for the people.
Good morning.
David Harris for the people.
Good morning.
Honor rights for the people, Your Honor.
Thank you. Good morning. And Mr. Peterson is present via Zoom. Mr. Peterson, can you both see and hear the proceedings?
Yes, I can. Thank you, Your Honor.
And do we have your consent to appear via Zoom this morning?
Absolutely, Your Honor. Thank you.
All right, thank you. We are on this morning for the defense motion to seal. The motion to seal was directed at a single exhibit that was attached to the motion under Penal Code Section 1054.9, as well as the people's opposition to that motion to seal and the reply that was filed on behalf of Mr. Peterson. I'm prepared to hear argument if all parties are ready to proceed. This was the defense motion. Ms. Mitchell, I will hear from the defense first.
Thank you, Your Honor. The motion to seal that's before the court is pretty straightforward and simple. Mr. Peterson is seeking to keep private certain witness information that was obtained from police reports for all of the reasons stated in our pleadings. So unless the court has any questions for us, we're prepared to submit on our pleadings, and we would respectfully ask for an opportunity to respond to any arguments the prosecution may raise today.
Okay, that's fine. You'll get an opportunity to reply. I guess the question that I have is every version of the exhibit, the one that was attached to your motion to seal and the one that was attached to the 1054.9 motion that is the target of the motion to seal, were filed with the court redacted. What is it exactly that you're seeking the court to seal, since everything that is in the record already has the redactions that you're looking for?
We're just asking for those redactions to be kept in place so that that information is not made public.
Okay, thank you. Comments by the people?
Thank you, Your Honor. Good morning.
Good morning.
I'll be brief. First, there was some debate on our end as to what was actually being requested by the defense in their motion to seal. Was it to file under seal solely that November 14th letter requesting post-trial discovery that they sent to our office, or were they looking to seal more? So we had some debate amongst ourselves. And the reason for that is the language in their motion makes it unclear what they're asking for exactly, because on page 4, line 21, they write, defendant Scott Peterson is asking this court for permission to file certain information under seal and a redacted exhibit that is public-facing in support of his motion for post-conviction discovery. The motion further states the redactions cover personal identifiers of witnesses, potential suspects, individuals with knowledge of potential suspects, and other sensitive information related to counsel's investigation. This seems to suggest more than just the November 14th letter, since both the motions and the multitude of exhibits attached to both motions contain redactions or omit information up to and including the point of having anonymous witnesses. Further, what we viewed as a potentially very vague and therefore expansive request also asked the court to permanently seal the items. This is evident in Mr. Harris's statement to the court when we were here last, where he said, as of this hearing, and it remains true today, we don't know who these witnesses are. This includes DM, ST, KM, KW, TS, and KD, assuming I have those letters correct because some of the redactions were such that it was kind of hard to see the letters. So this remains our concern. In his reply, the defense attacks the prosecution at one point and essentially accuses the people of lying to this court about witnesses who have not been identified to the people. That was at page 2 of their reply on line 10. Yet it was in fact counsel who stated, the identity of the witnesses whose names are redacted in the declarations that Mr. Harris is referring to have stated they are fearful of retaliation by the Modesto Police Department if their names become known and have asked that their names remain sealed. That's at the transcript on page 15. We just wish to ensure that in responding to these motions with very lengthy attachments, that we're able to address in a very fulsome way all of the various allegations being made in those documents. Further, as we've noted, they have requested redactions in that letter of 40 individuals and 2 addresses. Of those, 10 individuals and 2 locations are actually identified in the defense filings or their informal discovery requests. So a full 25% of those people, their names are already out there. Almost immediately upon the time of their filing, all of those documents were published by the media, so the information is out there. It begs the question how serious they are about protecting the names of these people, given that, at least outside of the people whom they only identify by initials. So there's a simple solution to that. If the concern is sealing of that particular letter, that particular letter as an exhibit could be withdrawn from the motion. It does not add to their motion. It's not necessary to their motion. It largely provides the same information as what is contained in their motions. And it also injects a lack of clarity, since frequently what is suggested in the footnotes regarding what the content of the exhibits will be is not necessarily what is actually provided in the motion and the attached exhibits. And
let's bring in criminal defense attorney and former prosecutor Brian Silber, who is standing by watching this hearing with us. Brian, it's good to see you. This is a situation where the defense, the LA, Los Angeles Innocence Project, they want to file under seal anything going forward that relates to potential witnesses. They call them either potential suspects, possibly Good Samaritans who came forward with information. What is the process for sealing? What does that look like that's different from how things are filed in court anyway?
So it sounds like we need a little bit more information about this particular circumstance, but you have to understand we're dealing with public records, and they're public for a very important reason. We need transparency in our legal system, and that's something that protects litigants. It protects the public. It's a protection against the government that they shouldn't conduct criminal justice proceedings in secret. However, there are limited circumstances where certain things are withheld from the public record, and they get sealed or they get redacted. An example might be the full name of a minor. Some of those initials may reference minors. I don't know if that's true or not, but that would be a reason. People's date of birth, social security, anything that would be sensitive, you can motion the court to exclude from the record. The bigger picture here, I don't know. I think it's yet to be seen. We need to hear the rest of the arguments.
I love that you're sharing the reasons we typically would see things sealed, but in this situation, they're saying because it's so high profile and they want to protect these people from intense scrutiny that they want this sealed. Brian, stand by. We do have to squeeze in a break. We want to get everyone back inside for more of that hearing there in San Mateo County, California, in the case of Scott Peterson. Don't go anywhere. now to the hearing for a convicted killer of his wife and his unborn son. Scott Peterson, 20 years later, is in front of a judge remotely today. The LA Innocence Project is representing him, and they're pushing to get him a new trial all these years later, saying that his rights were violated in that first trial. Let's go back in.
So the defense's actions also speak to the seriousness of this motion. They now claim that the people are wrong, that the California Rules of Court 2.550 and 2.551 govern this motion to seal. That's in their reply at page 4, line 3. When it was the defense that filed this motion in the first place, stating this motion is made pursuant to California Rules of Court 2.550 and 2.551. The defendant does admit in his reply in a footnote that Mr. Peterson's motion to seal cited California Rule 2.550, 2.551, not that it was made pursuant to those sections. This sort of hit and run approach deprives the people of really understanding on what basis the defendant is claiming the legal right to seal anything. Instead of starting over, they just simply say, well, oops, and move on. Even under the defendant's new position, however, those rules are a good starting point. I would like to address one comment in defense counsel's motion that we have refused to provide any discovery to which they are entitled, is the claim. And I'd just like to note that current counsel substituted in and replaced prior habeas counsel on the pending habeas on November 13th of 2023. The next day, they sent us an email with the 50-plus page letter at issue here, requesting literally hundreds of items, the bulk of which had been either previously provided to prior counsel or no longer existed due to being affiliated with unrelated cases and the passage of 20 years, or never existed in the first place because their existence is based on supposition and speculation. And in addition to that, there was a request for DNA testing. So this letter arrived the week before Thanksgiving and the Christmas holidays. On December 14th, we suggested a meeting with them in January. And on January 17th, we were served with the motions at issue here. We have continued to review the various requests in these very lengthy motions as we work on our responses. This is an incredibly time-consuming process. And this is not the first time that the defense has brought such motions. He's previously brought both a 1405 and a 1054.9 motion. So in sum, our suggestion is simply to withdraw that letter from the discovery motion. Then no sealing discussion is even required. 2, we don't believe the defense has established good cause by substantive evidence for their request because there's no substantive evidence included. But the fact of the matter is, Your Honor, we don't really have a concern with having the pleading documents have initials for these citizens who've not been previously identified because we know who they are. We do, however, request full disclosure of the unnamed witnesses who we have no idea who they are. And having said that, just the last thing is when we're done with this portion, I have discussed with Ms. Mitchell a motion that we're going to be filing for judicial notice and something we'd like to file, and we've already given her a copy of the CD, and it's the complete reporter's transcript with an index. So.
Okay. All right, so let's stick with the motion to seal, and then I will take up that discussion that you just referenced. Ms. Mitchell, your reply to the people's comments.
Thank you, Your Honor. Mr. Peterson has 2 objectives. One is to get the discovery and the DNA testing that we're requesting as soon as we possibly can. The second objective is to protect the integrity of our investigation that is ongoing. The motion to seal, I did not expect it would become this convoluted. I agree with Ms. Fladiger that it makes sense to withdraw the exhibit at this point. We don't need it. We're entitled to our discovery without it. So to simplify things and keep things moving forward, hopefully expeditiously, we will withdraw that at this time.
Okay, that's fine. The court will direct that the exhibit be returned to counsel, and it won't be considered as part of the motion. And that moots the sealing request. So there's no need for the court to rule on. In terms of the comments about judicial notice, what was the motion that you, what was the discussion that you and Ms. Mitchell had about dealing with that today, and what is the proposal in slab?
So, Your Honor, we both referenced in our various pleadings that to start with just today, and I've given Ms. Mitchell a copy. We have a motion for the court to take judicial notice of the entire reporter's transcript. We have included a CD that has the entire reporter's transcript on it, including an index, so that it's much easier for court and counsel to go exactly where they need to go with a citation. We discovered during this process that our reporter's transcript doesn't coincide with the defense's reporter's transcript, which is a problem in terms of citations. And so we're trying to address that issue now, early, and make sure we're all citing to the same transcript. We will, at a later time, I think with the filing of our motion next Monday, also be requesting additional judicial notice, and we will include at that time additional CDs, and that includes some of the very documents the defense has requested as well, such as the new trial motion, California Supreme Court opinion, petition for habeas, and a variety of other documents. We'll put them all in one CD.
Okay. So what is the proposal for today? Are you essentially just previewing that that's coming, and are we trying to set some kind of a filing schedule for the request for judicial notice in case there's either opposition or a difference between what the people are asking for judicial notice of and what the defense is seeking judicial notice of?
Well, if Ms. Mitchell is in agreement, we'd like to go ahead and submit this motion to the court today. I don't believe she has an opposition to it. It would get the disc in the hands of the court that much more quickly.
Okay. Ms. Mitchell, comments by the defense?
I haven't had an opportunity to look at this yet. I would like to review it and compare it with our copy of the record and make sure I understand what the differences are. But I don't foresee any objection. I just would like an opportunity to review it first.
Okay, that's fine. So if Ms. Vladegar.
All right, we're going to hit the pause button because we do have to get to a break. But you heard there, it sounded like the defense counsel for Peterson says at this time they're going to withdraw that motion to seal those witnesses because they don't need this exhibit, but certainly still a concern for them. They want these witnesses who are unnamed to not be hesitant to come forward with information. Don't go anywhere. This is Court TV Live.
First off, I'm coming on for a correction first. In the previous story that I was jovering, I said that I turned it over to Anchor and I said Julie Grant. I apologize for that. That was Julia Janae. Two totally different people working with Court TV. Julie Grant, Julia Janae. That's who's covering this story also. And you'll hear from Julie Grant a little bit later as I close out this edition of Bethea'S Byte Reloaded. As far as the Scott Peterson hearings motion to for a new trial, I'm not totally sure whether he's gonna whether that's gonna happen for him or not, because I believe even back then that he did kill his wife and unborn child. But I'm listening to what the defense is trying to get in order for Scott Peterson to get this new trial. So I'm gonna go ahead.
Tonight, on Closing Arguments, a deep dive into today's gripping testimony in the trial of Chad Daybell. The self-proclaimed doomsday prophet is charged in the murders of his previous wife and his current wife's children. We'll bring you the key moments you may have missed as our experts weigh in. And could Scott Peterson be exonerated for the murders of his wife Lacey and his unborn son Connor? We have the latest from today's hearing with insight from our think tank.
closing arguments tonight at 8/7 Central, only on Court TV.
Welcome back to Court TV Live. The Los Angeles Innocence Project is arguing for a new trial this afternoon for convicted wife killer Scott Peterson. They say new evidence in this case that dates back to 2002 that it could prove his innocence. He's been behind bars ever since. Let's go back into this hearing that's unfolding now.
Yes, Your Honor, one additional thing. In the record, in the pleadings, there are citations to exhibits. And the people will be citing to numerous exhibits as well. Our understanding, those are exhibits are currently in Modesto, so that's going to create an issue for this court to be able to see those. So what we're attempting to do is either photograph or use from the clerk transcript on appeal, copied versions of some of those particular exhibits. We would like to save the court and your clerks the time of trying to figure out how to take an exhibit that already exists and with a new exhibit and giving it a new number and so on and so forth. Is, again, if it would be agreeable with Ms. Mitchell, what we'd like to do is those particular exhibits, we will keep the same numbers from the trial. We will identify them as trial exhibits with those particular numbers. If they are a document, we will attach the document. We will take photographs of the exhibits as they have done with their motion, for example, on the boat cover. We will put all of those onto one particular disc, and we would like to, again, lodge those with the court because I don't think the court or the clerks wants to file duplicates of what's already in the court record. And some of them may be under seal that we are asking the court to deal with based on, for example, some of the autopsy pictures. The other thing that would be a potential issue in the defense's pleadings, they had referred to certain bait stamps, as we refer to them, police report pages. We will be having those citations as well. Those are not part of the trial transcript, but they may have some of the same type of information if it was a tip page, where there would be information that would need to be redacted. Again, what our intention is that we will identify them by bait stamp page number, and we will have a separate disc for those particular items. So we'll have one that's a court exhibit, one that will be something that refers to prior discovery, and we will attach those as part of the procedural attachment to our particular responses to the next two motions.
Okay. So essentially what you're asking is to whether or not, Ms. Mitchell, are you going to have any objection to either the procedure or the nomenclature for exhibits that's proposed by the people in their filing of responses?
Is the prosecution planning to include all of the exhibits, everything from trial, everything?
It's not our intention, but when we specifically cite to one, we are going to provide it to the court. So it's either we ask the clerks to obtain it from Modesto and bring it to the court, which might be difficult in some cases, or we attach the photograph like they did to theirs. So we think that's the easiest for the specific exhibits that we are going to use. If the defense wants us to include some, we could add those to the discs as well if they'd identify them for us.
Okay, so bottom line, what you're proposing, Mr. Harris, is that when you file your responses to the pending motions, either the trial exhibit or photographs, you want the numbering conventions for those exhibits to remain consistent with the trial to save duplication of effort. You're willing to meet and confer with the defense to include in the materials that are provided to the court with trial exhibits anything that they might be citing to. Am I correctly stating your position?
Yes, that's acceptable to the people.
And Ms. Mitchell?
No objection.
Okay, that is fine. To the extent that you believe that it is necessary to file any of those things under seal or lodge them and seek court permission to file under seal, that will require a separate motion. I can't do that by stipulation. But the process that we went through today, 2.550A3 seems pretty clearly to exempt things that are lodged in a discovery motion and in connection with the adjudication of a discovery motion from the procedural requirements of 2.550. So.
One additional thing.
Sure.
Some of the exhibits, actually, if the court has looked at the exhibit index, the court will note that there are an extensive amount of items that are sealed currently.
Okay.
So technically, we could provide those to the court. They are already in a sealed condition. There's never been an order lifting those seals from any of the courts that have reviewed. So I think the court could just, if the court was to go downstairs and look in the exhibit room at something that's already sealed, we provide it to the court, not filing it, so that it does not become a new public record, so to speak. It would just be something that the court has under seal already.
I mean, if there is already an order sealing that exhibit and you're providing essentially a duplicate copy or a photograph, I don't think there's any barrier under 2.550 to filing it under seal because you have a sealing order.
Yes.
Yeah, that's fine.
Potentially we can confer with counsel or see what she indicates is the bait stamp pages, as they included them in their pleadings, it was more of sometimes cut and paste or attachments. For example, the tip sheets, as I mentioned, there are a lot of tips on there which has information from other individuals that's irrelevant to what we'd be offering. So we would put those pages in redacted except for the tip that we would be referring to or whatever information we were referring to, and identify it by the base page number and attach that as a separate disc, so we can deal with that one separate and apart from what's already previously been admitted in court.
Okay. Any thoughts on that, Ms. Mitchell?
No objection.
Okay, that's fine. All right. Is there anything else from either side before we recess for the day? Okay. Thank you all. Have a good day. That'll conclude this hearing.
Yeah, I stand by my earlier comment where I said that I'm not too sure whether Scott Peterson will get on a new trial or not as far as his conviction on the murder of his wife Lacey and his unborn son. But I give him all the credit in the world for taking a shot. Currently, he's in the Mule Creek State Prison in Amador County, California. We know that the judge has dismissed the motion to seal proceedings in the case. This case goes all the way back to 2002, where he was convicted of the murder of his wife Lacey and their unborn son, who if we caught the closing arguments advertisement, the boy's name would have been Connor. He's pushing for a new trial, in the hopes that not only that he'll be exonerated. We'll just have to wait and see on that, but I still stand by my original comment. Next up. Now, I am going to set this up with a trigger warning, because you're going to see something, and of course YouTube is going to see it because I'm on here live on YouTube, so they got to see this. Let me go ahead and set the stage for you. An 80-year-old man is charged with murder in an Uber driver shooting, in which was deemed a scam. Okay? 81-year-old facing murder charges for the fatal shooting of an Uber driver who investigators say was sent to his home by scammers demanding money from him. Now, I'm not gonna even try to justify anything or whatever the case may be. I'm just going to let the story speak for itself. And
I'm Vinny Politan. Thank you for joining us here on Closing Arguments. A big hour ahead. But first, let's get to this story. This one, a lot of people are talking about, involves a man, 81 years old. This is his mugshot. He's locked up. This is William Brock. What's the story behind William Brock? He got a phone call. And you know, scammers go after, our seniors when they're trying to get money. Someone, we don't know who, apparently called him up and was trying to extort money from him, saying that his nephew was in jail, and he alleges that he was getting threats from these people who were making a call, and they wanted $12,000 from him. 12 grand. So what's the arrangement? The arrangement involves a pickup of the money. And these scammers allegedly send an Uber driver. This is the Uber driver. Take a look at her photo. It's Lolita Hall. It's a hard-working woman just trying to do a job. Has the app, works for Uber. Oh, it's a package pickup. All right, I'll go to this residence and pick up a package. Well, she goes there and she waits like 30 minutes for the package to come, and no one comes out with the package, so she goes to the door. And when she goes to the door, that's when she is confronted by William Brock, who is holding a gun. Now, she's not threatening him or anything. I'm just here to pick up a package. What's going on in his mind? Who does he think she is? How is she connected to the people threatening my family? Well, what happens next is incredibly tragic. William Brock shoots and kills her. Now, part of this confrontation is caught on video. I'll give you a warning. It's graphic in nature. You'll hear some shots. Part of it we cut out because of the screaming, but the part that's cut out, we're screaming. She is like begging for her life. Please stop shooting me. We're going to play that video for you now. This is from her car, right? She's an Uber driver, so she has a dash cam video to protect herself from accidents and things that are happening, to record what she's doing while at work. Unfortunately, she recorded what happened here. Let's take a look.
Stop. Stop. Or I'll call 911. No, you're not leaving. Right. No, you're not. You're not leaving in one hole. Stop. Give me that phone. Stop. Give me it. Stop. Give me it. Help! 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 Give me that phone. Help! I'll shoot the other way. Help! Help! Come on, get out. Help! Sir! Yeah. I'm here to pick up a package. Yes, I know what you're after. You're after the... Help! 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 I'll shoot you in the head. Don't do that, please. Don't, sir. Please don't. Who do you work for? Over. It's right up there. You can see it. You can see it. You can look, sir. Please. Just look. Well, hold the property. Right here. Stop! Oh, shoot you. Give me that phone. No. All right, sir. Please, don't shoot me anymore. Please. You need an ambulance. Please. 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 Let's talk.
So, this situation is created by people who aren't there, who may know him, clearly don't know her. They put her in an extremely dangerous position. And this man, he's asking her, who do you work for? She's saying, Uber. I work for Uber. And he's concerned about her talking on the phone. Now, I don't know what's going on in his mind, but he doesn't stop shooting. He does call 911. He calls 911. Let's take a listen to that.
Yes, I need the sheriff and the ambulance real quick out here. There's been a shooting.
A shooting? Who shot?
Some black woman come to the house here.
Who did she shoot?
Well, I've been threatened all morning.
Okay. Okay, where did the black woman go?
She's laying here on the driveway.
Did you shoot her?
Yes, I did.
Okay. She's laying in the driveway?
Yes.
Okay. Okay.
She's bleeding some. And
okay, where did you shoot her at?
Well, I shot her in the leg the first time, and I shot her in the shoulder.
Okay, so you shot her in the leg and the shoulder?
Yes.
Why did you do that?
Because I was threatened that she was going to come and kill me.
She threatened to kill you?
No, it's the guy on the phone that's been trying to get money out of me.
Okay, do you know who the male is?
I could give you his name, but Joseph somebody.
Joseph?
If that may not be his right name.
Okay.
Let's just get the sheriff out here. And
we got him dispatched. I want to stay on the line with you, okay? Is anybody else with her out there?
No.
Okay, so she's by herself?
And I'm by myself, too.
Okay. Is that her in the background?
Yes.
Okay. Okay. Okay, you don't know her other than she was making threats?
I've never seen her before.
Okay. 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 Did she come and knock on your door? Tell me what happened.
There was a guy on the phone center here.
Okay.
So
the male on the phone was trying to get money from you, and she was knocking on the door at the same time?
Yes.
Okay.
And he was telling me he was going to kill me and the family and everybody else around me.
Money, okay. And he said he was going to kill you and the family?
Yes.
Okay.
And he thought he would be on his way here now. He claimed he was in Springfield, but...
Okay, the male said he was in the Springfield?
But I don't believe it.
Okay.
Help me, please.
Okay, tell her we got the medics coming.
Well,
okay, tell her we got the medics coming, okay? We got medic and the police department coming. They're coming full force.
Well, get him here quick, because I'm not comfortable being outside here, because they said they had us running over us.
It's an old man that shot the lady.
Just way back.
It's an old man that shot the lady.
They're coming to help you.
The caller is the shooter. The caller is the shooter that I have on the line. The caller is the shooter that I have online. I can hear the female screaming in the background. Help me. I need you to put the gun up before they arrive, okay?
And if you would also part note for LT.
Yes.
Okay, put the gun up for me. Put it inside the house or something, okay?
Yes. But she's not going anywhere.
Okay, okay. How bad is she bleeding?
I don't know.
Okay, and you said you hit her in the leg and the shoulder, right?
Yeah, I think it was the shoulder. She got a big sweatshirt on. I can't really tell.
Okay, okay. Are they out of the ambulance yet, or are they still there? Are they still waiting?
Yeah, the paramedic. I shot her.
Shot her? What happened to you?
She busted my head on the door.
You know her?
No.
He's been charged now. Let's take a look at those charges. Murder, which is purposely causing the death of the victim. Yeah, he purposely caused the death of this victim. Murder during or as a result of committing a felony offense, right? That's the assault with the gun. Murdering as a result of committing a felony offense. Kidnapping. He's not letting her leave. That's on video, felonious assault, felony kidnapping. So you look at the charges for what he did, yeah. But the question is, why did he do it? Now, he wrote some notes in the home that were recovered. The defendant here that you're looking at, William Brock. And in his notes, this is what the investigator said, when I went into the kitchen, I read the spiral notebook that was on the table. It shows someone wrote notes about bail money, $12,000, and had a case number. So the scammers are trying to get him to pay bail money. Are they making threats, not making threats? That part I'm not sure because there's no notes about that, but $12,000, and they give a case number. This is out of Ohio, OH57994. And at the bottom right-hand corner was written Black Acura driver Letha. So he's writing down the information about the driver. And then Lieutenant Schultz and Detective called this counted money that he had. He had the $12,000 there. So he's buying into this on some level. I'm not sure. Like, it's difficult to get inside of his mind and why he did what he did. But this was a relatively sophisticated scam. I'm sure it's not necessarily uncommon. The complicating factor in all of it is when they went for the pickup, the scammers used the app. They used Uber to try to get the money from the victim.
I paused it right there for this reason, just to simply say that from everything I've seen and heard so far, William Brock turned himself from victim to felon just like that. He must have taken the mindset that he knew he was about to be scammed and he was not having it. But unfortunately, he went about it the wrong way. And the innocent victim in the case, the Uber driver, is dead. All because of somebody trying to scam this man out of $12,000. You want to be careful of who you're dealing with by phone. You want to be careful with who you're dealing with by email, by digital correspondence. No matter your age, or as my dad would say, God bless his soul, it doesn't matter who you are, from 8 to 80, blind, crippled, or crazy. You gotta be careful. Or else something like this is gonna happen. And if this happens, who knows? Either you could be that Uber driver, or you could be William Brock. But either way, honestly, this story has two victims, one of which turned himself into a felon. The question now is, will he face any kind of punishment? And if so, how severe? Let's go back to video.
Because he's the victim of the scam, but he's the defendant who shot the real victim in all of this, the Uber driver. let's try to unpack this a little bit. Let me bring in my special guest joining us right now. Kenneth Gray, retired FBI special agent, senior lecturer at the University of New Haven, joining us from New Haven tonight. Kenneth, great to see you tonight. Your first thoughts about the nature of this scam and how intricate do you think this is, or how common are scams like this where you're trying to get cash from seniors, people who might be a little more vulnerable, by phone?
Hi, Vinny. Good to be with you again. So I've heard the same scam, a slight variation of people being called by what's supposed to be grandchildren that are being held in Mexico or other countries, and they're being held by the police and they need bail money to get out. So this is a variation on that scam, which has been out there for at least 10 years. And in this particular case, the Uber driver is being used as a cutout. So this is clearly a scam, but at the same time, even though Mr. Brock fell for the scam, his life was still not under threat. He was not under risk of threat of death or grievous bodily harm. Therefore, self-defense does not work in this case.
No, it's not. I mean, the Uber driver was trying to get away. She was trying desperately to get, as soon as she saw the gun, she's like, I'm out of here. I'm just going to go. But she's picking up the phone, and he seems concerned about that. As I listened to Brock, the shooter, the man with the gun, he seemingly believes she's part of this, that she's working for the people who are shaking him down.
Absolutely, I agree. He does not realize she's an Uber driver and that she is an innocent third party, but instead believes that she's there making the pickup with her partners. And so he buys into it, but buying into it in no way excuses his, shooting her.
But let me ask you this. How difficult should it be now for the FBI or whoever else is investigating this to track down the people who put all these wheels in motion? The ones who called the defendant Brock, the shooter, the ones who used the Uber app to have this innocent woman thrown in the middle of all of this.
So law enforcement can go to Uber and get the number that was used to make the contact for this. And if that's not available, there is this push technology that was used in recent cases involving pedophiles with apps being used to hide the identity of individuals and use that to reveal who made this Uber contact.
So from your perspective, sitting here tonight, because obviously we haven't heard about any arrest of the person or people responsible for putting this in motion, how confident are you that they could be tracked down? And do you believe that they're actually in this? I would think they're in this country, right? Because they're getting, it's a cash transaction. So we're not talking about people from abroad. It's likely someone close by, I would think.
It could be, or it could be somebody abroad with local contacts. That happens also. But nonetheless, I'm fairly confident they can track down the person that made this contact. But the question is the legal theory here of beyond what their responsibility is for this murder.
Absolutely.
That is, they were responsible.
Well, we're going to get into that with our legal think tank coming up next. So
great.
Yeah, because it's layered and it's complicated. But the other part of this, right? If the Uber app is used to pick up the package, there has to be a drop-off point. And if you know where that drop-off point is, that should lead to some really significant information for investigators here.
Absolutely. So the extortion that is going on here, it may be to the individual that is behind this, or it could be to a cutout, but nonetheless, that cutout is a pathway to the person overall responsible for setting this all into motion.
Now, let me ask you one more thing. They used a particular family member here. He kept saying his nephew. You have to speak with the nephew to, number one, make sure he's not involved in all this, which he could be, I don't know. And I think it would be important also to know if they knew the name of the nephew. And if they know the name of the nephew, they know him. Like, how do they pick the targets here? Could it be someone who knows him? Or is this stuff that these scammers are just getting from online and getting family members' names all online?
Yeah, the cases that I'm familiar with from the past where the similar type of scam was being used, it was Facebook. They were getting the information off of Facebook, finding likely targets to go and contact, and having names of grandchildren that they could go and approach them with. But the nephew definitely has to be interviewed to see if they have any role in this.
Yeah. Wow. I mean, this is really sad. It's
tragic.
So sad. Kenneth Gray, I'm so glad we had an opportunity to have you on tonight. We appreciate your valuable time and your insight from all your experience. Kenneth Gray, over there at the University of New Haven, thank you so much.
Anytime, Benny.
All right, when we come back, we're going to dive into, Kenneth Gray was asking the questions. Do Josh, Molly, and Daryl have the answers? We'll find out next.
That's one thing I do agree on, how sad this case is. Like I said earlier, there were two victims in this case. One of them turned himself into a felon the moment he fired the gun and shot the Uber driver. Now that victim is deceased. That victim was pretty much doing her job before this. And William Brock, I don't know what the entire situation is, but he was just trying to comply with somebody who was trying to get $12,000 off of him. For what reason, it's unknown to me. Anyway, the article goes on to say that and he called. You heard him call 911. On himself. The Clark County Sheriff's Office said the investigation revealed that Brock and Hall were both caught up in the scam. Brock for his cash and Hall as the unwitting courier. Brock's decision to take matters into his own hands made his actions criminal. Brock told investigators that an unknown man called him multiple times that morning, threatening to kill him and his family if he didn't pay a $12,000 ransom to get Brock's nephew out of jail. Inside Brock's home, officers found an envelope stuffed with $12,500 cash and a notepad with a case number and court appearance details jotted down, and Black Acura driver Leotha written in the bottom corner. Brock is expected to plead to the charges sometime at some point, and it's just maddening how scammers will do anything to get whatever money they can, and off of especially off of the elderly. And honestly, while I feel bad for William Brock, to a certain extent, my true sympathy goes to the family and friends of the Uber driver who was pretty much an unwitting, courier. She didn't deserve to have her life snuffed out like that. Okay, I'm gonna go to the next story here, and again, I'm going to put up an early trigger warning, especially for myself, because this is the kind of story that's gonna set me off. Okay. Now that we got that, here's the story. We have a malnourished 5-year-old girl is deceased in Indianapolis. Five years of age. I'm gonna see if I can pull this photo up for you guys, and I want you to see just exactly what we're dealing with. Take a look. Take a look at your screen. That was 5-year-old Kinsley Welty. Cute little thing, isn't she? Cute. But now, no longer with us. Why? Instead of me trying to figure out the answer, I'm gonna go back to Vinnie Politan, and I'm gonna let him give you all the details.
Vinnie Politan, thank you for joining us here on Closing. We're going to talk about will not be easy. The next story we talk about is it's bad. It's really bad. But it goes, I believe, beyond just those directly responsible. I think there's potentially more responsibility and the responsibility of our system, because we need to protect children. Somehow, some way, the system needs to protect children that are not being protected by those who should be doing it. And in this case, we're talking about 2 generations not protecting this child. Let me introduce you to Kinsley Welty, 5 years old, passed away on April 9th. Police were called, reports of an unresponsive child, and this 5-year-old girl, the autopsy results say the cause of death, she likely died of malnutrition. She wasn't eating anything. She wasn't being fed. She wasn't being taken care of with the bare necessities of life. And you look at her face, you look in her eyes, you look at the smile. She's able to squeeze out not in this picture, but this child was tortured. Now, let me introduce you to the suspects We begin with her mother, 29 years old. Not some teenager who doesn't know what's going on in the world. 29 years old. Charged with murder, criminal confinement, battery on a person less than 14 years old. Suspect number 2. You know who he is. That's mom's boyfriend, 27 years old. Child neglect resulting in death. Criminal confinement. Now, the kicker. Grandma. Grandma. Criminal confinement. What grandparent confines your 5-year-old granddaughter? Who even thinks of doing that? I'm a grandparent. My granddaughter's 5.
Hold up just 1 minute. I gotta back this up because when I first caught this article, I knew about 29-year-old Tony McClure, the mom in this case. I knew about the boyfriend, Ryan Smith. But grandma? Really? Grandma? I might have been seeing things. Hold up.
In death. Criminal confinement. Now, the kicker. Grandma.
Okay. Now I see it. Do I believe it? No. She's right there in my face. Yet and still, I don't believe it. But it's like I said once. In fact, I've said it hundreds of times. The monsters no longer hide in the closet. The monsters no longer hide under the bed, kids. They walk in daylight. And the monsters, these monsters, in this case, 2 of them are called Mom and Grandma. And 2 of those monsters make me sick. These monsters turn my guts in 2. And I take this, and this is one of many cases like this that I take personally because I lived it. I know what it's like to be malnourished. I know what it's like not to be fed as a child. I know what it's like to be abused. But to take it to this level, oh my God. This story is making me sick already.
Grandma. Criminal confinement. What grandparent confines your 5-year-old granddaughter? Who even thinks of doing that? I'm a grandparent. My granddaughter's 5. Those thoughts don't come into your mind. You're trying to do everything and everything for that grandchild. They replace your child. Sorry. Sorry. The pecking order changes when you become a How do you do that? Let me read the quote from police. The circumstances of Kinsley's death are horrific and beyond comprehension. No human being, let alone a child, should be treated like she was. These alleged suspects, if convicted, should never step foot outside of a prison.
That police statement says everything I want to say clean. That statement from police says everything I want to say without using one expletive. Because trust me, those monsters would have gotten every last expletive I could throw at them. I've said this on many occasions. I've said this on plenty of occasions, and I still say it today. Parents, you have but one job. One! Yes, there are many parts to it, but you have but one job. Love and protect your child. Tony McClure, you failed. You failed. Then on top of it, you let your boyfriend do it. You failed twice. Then there's your mother, Tammy Halsey. Grandma, you have a job. Like Vinny said, the pecking order changes. Mom's attention shifts from her child to grandchild, which means Grandma's job is to love, protect, and at times spoil that grandchild rotten. At times, spoil that grandchild rotten. Grandma, you failed. You failed. And because of the severity of your failure, how much do I agree with that? Shoot. If you're a betting person, head to Vegas now. Bet it all. Let it ride. Because I see Because I'm telling you now, I see all three of these monsters getting convicted. I see all three monsters getting put behind bars. And trust me, they deserve every bit of time they get.
That's from the Indianapolis Metro Police Department. Now some of the disturbing details. Because this really happened. This really happened. She spent most of her time locked in a small closet with a dresser blocking the door. She was frequently duct taped and tied to her bed by her grandmother so she wouldn't get up and get food. Of course she's going to try to get up and get food. We just did the Ruby Franke, Jody Hildebrand case. Thank goodness those children survived, because this is what would have happened. Authorities found fecal matter and lice on her head, hair, and feet. She weighed less at 5 years old than she did when she was 2.5. The mother had already served time, okay? Had already served time for neglecting her back when she was 3 weeks old. DCS had visited earlier that day, but didn't see Kinsley. My guess is she was locked in the closet. We have more details tonight from Rachel Wilkerson with Scripps News, Indianapolis.
If the parents aren't going to love and protect them, and the state's not, who's going to protect them?
Flowers, balloons, and a card saying Forever 5, always in our hearts, baby Kinsley, sit outside the Southwest Side home she was found in. Metro police say the 5-year-old was unresponsive, thin, with sunken eyes, and had feces on her feet and in her hair. Riley Hospital reports Kinsley was so malnourished, she weighed more at 2.5 years old than at 5.
Traumatized, like terrific. Words can't describe the feelings. Feel guilty to eat sometimes.
Grandparents Tricia and Brian Welty say the warning signs of Kinsley's health were reported, but say the Department of Child Services let them down.
We just don't want her death to be in vain. We want change. We don't want any more kids to have to die because of the failure of the system. It's not right. She was in our home, and she was safe, and she was loved. And she was handed back to her abuser, and she's not here anymore.
The Weltys say Kinsley temporarily lived with them twice after other reports of mistreatment. In 2018, her mother, Toni McClure, was formally charged with neglect when Kinsley was just a baby. The officer said the home was in one of the worst conditions he'd ever seen and noted a 3-week-old that appeared to be malnourished. Her mother served 21 days in jail for that case.
When she came to us the second time, she was bruised from head to toe. She had clumps
of hair
missing throughout her whole head.
And she was given back.
And she had already tried to starve her to death when she was 3 weeks old. And they gave her back.
Following a welfare check in 2021, the grandparents say they were fearful Kinsley would die.
I pleaded with DCS before that court case, my concerns about all that, every bit of it, and I was ignored.
According to police reports, the mother says just before Kinsley died, DCS was at the house but didn't see Kinsley. McClure says Kinsley frequently expressed that she wanted more food or that she was thirsty, but says she had a desire for her to be out of her life. The Weltys want DCS to improve its reunification process.
Your priority should be the children, their safety. It shouldn't be getting them back if the parent's not the safe person, and they failed her. I just want justice for Kinsley. I pray to God that they don't plead this down. I pray every charge sticks.
Rachel Wilkerson, WRTV.
I have a lot of questions tonight. I think we all do. This is a total letdown. You know, when I say at the end of the show, don't forget to hug the kids, obviously, I mean like your own children, but I mean us as a society, us as a system. Like this is our top priority, is to protect children. And sometimes they need protection from their own mother, their own grandmother. That's when DCS has to step in, but it's got to be with eyes wide open. Same thing in courts. You know, in the courts, they want the reunification. They always want the biological parent with the child. I get it, I get it, I get it. But come on, open your eyes. Open your eyes. Do the job, do the work. There is too much at stake. If a child's being abused at 3 weeks, you think mom is getting better? Well, if she is, stay on top of what mom is doing. Stay on top of it. Verify it. Make it a priority. A 5-year-old can't pick up the phone and make the call. All right, I need a little help. I'm going to bring in our special guest. Joining us tonight in Springhouse, Pennsylvania, international parenting expert, nationally recognized relationship expert with a doctorate in clinical psychology. Dr. Sue Kornbluth is back with us. Great to see you tonight.
You too, Vinny.
You know,
wish it
was a different circumstance.
Yeah, that's what I'm saying.
It's not. The first question I have, I'm trying to understand, is why do they fight to get the child back to begin with? Right? What is going through your mind? You're fighting to get custody of this child so you can abuse the child? I don't understand that.
Great question, Vinny. And yes, you know, oftentimes, though, I think what you're not understanding is that that mother or other mothers that, you know, their kids end up in the state services are also working with a case manager who is encouraging them to get better so that they can get their children back to them. So I don't know if everybody knows that. So this mother here probably had someone that was saying to her, you need to get your act together. You need to get better so that you can have your daughter back. Isn't that what you want? And they go along that line. And so therefore, the mother may not be ready to have her daughter back, but she is encouraged to do so.
And it seems the paternal grandparents, the ones we heard from from Scripps News, they were, you know, talking to DCS and expressing their concerns. And I know in a lot of these battles, the families don't get along and but like, could someone, you know, check and see if she's going to the doctor? Can someone check to see what she weighs? I mean, at 5 years old, she weighs less than she weighed at 2.5. That's not how it works with children. Children grow and they get bigger. My 5-year-old granddaughter, I have a tough time picking her up right now. And she's just tall and she's grown. And, you know, I'm not as strong as I used to be, but, you know, it's just the natural progression. This is outrageous how there's no one, especially DCS, who's jumping in and noticing this.
I mean, I'm as outraged as you are. I've been outraged for years. I've spoken out about this. If you notice once that abuse is going on, then you have to do your due diligence to keep going back in and checking on this child over and over and over again to find out what is clearly going on. Here you had the grandparents that just stated, Vinny, that they told Department of Human Services over and over what was going on with this child. The ball was dropped somewhere, and this is not the first time the ball has been dropped where a child has died. I don't know what we need to do to stop this, but we need to do something because more and more children are dying and being placed back into abusers' care.
Now, the other part of this, right? She, at 3 weeks old, there were problems. She was convicted, right? Then you get the case manager, things better. To me, that's when you should be on parental probation, right? And that parental probation should be for as long a period of time until this child would be regularly seen by whether it's teachers at school or someone, right? Complete that probation. But it seems like there's almost an incentive by DCS and by judges to get this reunification done. And we're doing it like this instead of like this.
I agree with you 100%. And reunification with a birth parent, in my opinion, is when a birth parent is safe, has been evaluated over time, and has had supervised visits with their children for a period of time as well. I don't know if there was any supervised visitation. I don't know what goals that this young woman had to meet, but clearly she was not in the state to take her child back.
And for DCS to make a visit and then the child's not there? Well, where is the child? She's 5 years old. She's not out on a date. You know, she's not at school. Where is she? Where is she?
So that's what I cannot understand either, Vinny, is how did they leave that house without seeing the child or finding out where the child was? I do not understand that. It's a great question. Look through the house. You know, the job was not done to the best of Department of Human Services ability. But there's other things that went on here too, Vinny. I mean, they were all...
Grandma. How about Grandma?
Let's talk about Grandma. Grandma knew what was going on. She was also participating in the abuse. I don't know if you read today, but I did, that she was duct taping her to the bed. Did you read that?
Yeah.
And nobody wanted to say anything, Vinny, because why? They didn't want to get in trouble.
Unreal.
Makes me sick. Makes me sick, Vinny.
Absolutely. Dr. Sue Kornbluth, great to have you on this Friday night. I'm sure we'll be speaking again. Unfortunately, it will be about stories like this, but you got to shine a light on it because things have to change. Absolutely have to change.
And I'm glad you are, Vinny. Take care.
Thank you so much. All right, folks. When we come back, our think tank is ready. I know they're angry about this story. The question is, how is our system of justice going to handle it? Brian Watkins, Judge Gail Byers, and Ben Chu up next.
I sat back and I listened to Vinny and his guests talk about this case, and the longer they talked about it, the sicker I got. Those three monsters, and I keep calling them monsters because they're not parents, and one is definitely not a grandparent. Those three monsters need to be behind bars, never to see the light of day. But I got another question right now. In the interview, we heard from the paternal grandparents. My question is, where was Kinsley's father? Where was he at when this went down? I'm looking for information. Oh, here's something interesting. They mentioned about McClure serving time in jail for neglect. All she served was 21 days. 21 days behind bars. Nothing about the paternal the girl's father. I stand with the paternal grandmother, Trisha Welty, who said the child's safety should be priority. It shouldn't be getting them back to the parent if that parent isn't right. They, DCS, failed her. I couldn't agree more. I couldn't agree more. And Vinny just referred to the Ruby Frankie case, and thank God for two differences between these cases. One, in Kinsley Welty's case, this was not filmed for YouTube. Second, in Ruby Frankie's case, none of the children are deceased. Thank God for that. Thank God for that. Those subtle differences. Those subtle differences, but they mean oh so much. My heartfelt condolences to the paternal grandparents of Kinsley Welty, and my utter disdain, my guttural disdain for you, Tony McClure, you, Ryan Smith, and you, Tammy Halsey. I'll say this one more time and I'll go on to the next story. I hope all three of you monsters be thrown in jail. No, not jail. Not jail. I hope the three of you are thrown in prison, never to see the light of day for what you did and what you didn't do for that child. Oh, and I got a bit of an update on this too. Almost forgot about it. I almost forgot about that. Oh, this is gonna go right back to where we started before, or as far as the video goes. Let me give you a good look yeah. Let me go ahead and give you guys a good look at two of these monsters. On your left, Tony McClure. On your right, Ryan Smith. Now, according to the article, It says in Indianapolis, mother and her boyfriend appeared in court Wednesday for the death of her daughter. Toni McClure, in my eyes, is not a mother. Five-year-old Kinsley Welty died on April 9th. Her monster, 29-year-old Toni McClure, is charged with murder, criminal confinement, and battery on a person less than 14 years old. McClure's boyfriend, 27-year-old Ryan Smith, is charged with 3 counts of child neglect resulting in death and criminal confinement. The child's grandmother, 53-year-old Tammy Halsey, is charged with criminal confinement. Prosecutors updated those charges on Thursday via X, formerly known as Twitter. I'm about to pull that up as soon as I can take this down. Give me one moment. Okay. All right, here we are. Prosecutor Mears announced today that 3 have now been charged in the death of 5-year-old Kinsley Welty, and they posted this. Earlier this week, Toni McClure, Kinsley's mother, monster, was charged with murder, criminal confinement, and battery on a person less than 14 years old. The state is seeking life without parole. Can't say I blame him. Ryan Smith, McClure's boyfriend, was charged with 3 counts of neglect of a dependent resulting in death and criminal confinement. Life without parole for him sounds good too. Tammy Halsey, Kinsley's grandmother. No. No, that's a monster too. Has now been charged with criminal confinement. Now, I'm going to do a little bit of digging in the law. This is Indianapolis law, right? Criminal confinement in Indiana. Yeah. Okay. I'm reading here that criminal confinement in Indiana is the knowing or intentional confinement of another person without that person's consent. It is a serious felony that can have severe consequences for the accused. The offense of criminal confinement is a level 6 penalty, which carries a maximum of 2.5 years in prison and a $10,000 fine. Aggravating circumstances can increase the offense all the way up to a level 2. The main criminal confinement statute in Indiana is Indiana Code 354233. Now that's the first thing I just read. Now let me look at neglect of a dependent resulting in death real quick. Neglect of a dependent resulting in death in Indiana. Oh my gosh. A person convicted of neglect of a dependent resulting in death may be sentenced to between 20 and 40 years in prison, with the advisory sentence being 30 years. In addition, the person may be fined up to $10,000. So, if I'm doing the math right, keep in mind this is judge's discretion. Ryan Smith could very well serve anywhere between 20 and 42 and a half years running consecutively. No, wait. 3 counts. Oh boy. I said that they didn't deserve to see the light of day. Ryan Smith is right up there. Right up there. It's a good thing we got X. Helps explain the law, you know? All I know now is these monsters deserve every bit of prison time they've got coming. And believe me, it's coming. Speaking of prison time, speaking of somebody with prison time coming in the death of their child, ladies and gentlemen, I give to you Leilani Simon. Oh, y'all don't remember that case. I know you have to remember that case. But if you don't, I'm gonna take myself.
We begin this hour in the state of Georgia, where Leilani Simon is charged with the murder of her 20-month-old son. You might remember he went missing in 2022, only for his body to be found a month later at a local landfill. Well, Leilani Simon was back in court Tuesday for a pivotal pretrial hearing. Before we bring you those key moments, here's a little refresher on the case. Court TV anchor Julia Janae reports. Little Quentin Simon was just 20 months old when he was last seen in his home in Savannah, Georgia on October 5th, 2022. He lived with his mother, Leilani Simon, her boyfriend, Danny Youngkin, and his grandmother, Billy Joe Howell.
The boyfriend woke up, saw the child at 6 a.m. Mother woke up at some other time later and reported the child missing at 9:39. I believe the call came into 911.
Local police and FBI began searching for Quentin that very day.
We have yet to locate little Quentin. We continue to investigate this incident. We got some assistance from the FBI. We got numerous interviews to conduct today, as well as downloading phones and things of that nature.
Leilani Simon tells police that Quentin's biological father, Henry Bubba Moss, took him, so authorities go to Bubba's home more than an hour away.
He was being questioned about where he was overnight, October 4th into October 5th. And proved to police satisfaction anyway that he had nothing to do with it.
Has there been any contact with Quentin's biological father?
We have had contact with him. He's not a suspect in this case.
After a week of searching for little Quentin, the Chatham County Police confirms everyone's worst fear. Quentin is believed to be dead, and his mother, Leilani, is the primary suspect, but no charges or arrests are made.
What are you doing? What is going on here? Where's the FBI? Where's Secret Service? Somebody needs to find this baby and lock her up.
After that announcement, all eyes turn to Leilani. Protesters, podcasters, and YouTubers gather outside of her home day and night. Nearly 3 weeks after Quentin was reported missing, Leilani and her mother finally speak out in an interview with WTOC News.
And if something does come up that I am at fault, I will take myself to that police station.
Then, 47 days after Quentin vanished, law enforcement find remains of a human child in a local landfill, and they arrest Leilani Simon.
Our search teams at the Waste Management landfill found what they believed were human remains. This afternoon, the FBI lab in Quantico, Virginia confirmed that they are, in fact, human remains. Additional testing, including a DNA analysis, is being conducted, and we have every reason to believe that this will confirm the remains are Quentin's.
That was Julia Janae reporting there. Now let's get you into Tuesday's important pretrial hearing. It all centered around a defense motion to suppress previous statements made by Leilani Simon. There was only one witness called to the stand. That's Detective Marion Lemons with the Chatham County Police Department. And in this portion, the detective describes her background knowledge of Leilani Simon.
Before we get into the particular facts surrounding the defendant's various statements in this case, I want to ask you some background, about some background information that will help, I think, set the scene, okay? Okay. In the general time period in question, we'll say fall of 2022, where was the defendant living?
So it is a address off of Buckhalter Road, 535 Buckhalter.
And is that in Chatham County?
It is.
Generally speaking, what area of town is it in?
We refer to it as the west side of town. It's right off of Ogeechee Road.
Can you describe, just briefly, I'm not asking you to give like a full layout or floor plan, but can you briefly describe the residence?
Yeah, it's a single family home, 2 stories with a fenced-in backyard.
And how many bedrooms does it have?
It has 4 bedrooms, but one of them has more been converted into a bedroom. It's probably a living room more.
Okay, but has been converted into a bedroom? Okay. And who, I don't know whether you said already, whose residence is that or was that at the time, I guess?
So it was owned by Billy Joe Howell and her husband, Thomas.
And who are they in relation to the defendant?
Billy Joe is Leilani's biological mother.
And what about Thomas?
Her stepfather.
Okay. At the time period in question, who else? I think we're up to 3 people now. The defendant, her mother, Billy Joe, and her stepfather, Thomas Howell. Who else, if anyone, was living in that residence in that general time period, fall of 2022?
Yeah, so Mrs. Howell's other son, Paul Simon, lived there as well. He lived upstairs. And then Leilani's boyfriend at the time, Daniel Youngkin, and then her 3 children.
The defendant's 3 children?
Yes.
And who were they, like give the rundown of their names and ages?
So Zane is her oldest. He was 3 during the time of this incident. And then there's Quentin, who was about 20 months old. And then Sky, who was 5 months, I believe.
And Sky was the baby that had been born of the defendant's relationship with Daniel Youngkin?
Yes.
Her then boyfriend?
Yes.
The other 2 children were the products of previous relationships the defendant had. Is that right? Okay. I think you mentioned that Paul slept in a bedroom upstairs.
Yes.
And that the defendant lived in a bedroom downstairs that appeared to be a converted living room or something like that.
Yes, that's where her, Daniel, and the 3 children lived.
Okay, so all 5 of them lived in that room?
Yes.
Okay. And did that room have any door that opened directly to the outside?
Yeah, the side where the children were, it led to the front door, which is an exterior door leading to the Buckhalter side of that residence.
Okay, and is this the door that people in this family referred to as the front door?
It is.
They call it the front door, but it opens directly into her bedroom.
Yes.
And does that appear to be a consequence of the fact that this bedroom is a converted living room?
Mr. Hilliard. I object. As to the relevance, my understanding is we're here for a Jackson Ditto hearing. I don't really understand the reason for the biological history lesson we're being given right here, but I don't see the relevance to what we're here for today.
Mr. Dean. Your Honor, we have a burden of establishing that all of the statements that the defendant gave were voluntary. For the court,
geographical residence doesn't do anything to establish.
If I may just finish my response. It is going to be necessary for us to do a certain amount of scene setting for the court to understand what these statements were, what she was talking about, and the general investigative context in which they were made. If the defendant wants to stipulate that they were all voluntary, then certainly the inquiry would at that point probably become less searching. But we have a burden and we intend to carry it, not ask for a little latitude.
Mr. Dean, I'm going to give you a little latitude. I am not overruling the objection. I am overruling the objection, but I want you to rein it in because I do understand the objection about where we are right now.
Now, let's go to the evening of October 4th / like the night of October 4th / morning of October 5th, okay? Who was actually present in the home on that day?
So it was Paul Simon, Leilani Simon, Daniel Youngkin, and...
You have an objection, Your Honor, as to relevance. He's getting into his case in chief at a motion hearing as to the voluntariness of certain statements.
If I may, Your Honor, this has nothing to do with the cameras. The court will remember that I've objected to every media request in this case. The very next thing that I'm going to get into is that it was the defendant who drew law enforcement to her residence by making a false report of a crime and representing this as a child abduction. Now that bears on voluntariness. It bears on the voluntariness of their statements that day and all the ones that followed, is that she brought the police attention on herself to misrepresent what she had done. This is really not very far. This is not far afield at all.
Mr. Hilliard. Your Honor, that's called his conclusory statement as to what the evidence reflects. It doesn't have anything to do with the voluntariness of a statement. If Mr. Dean wants to sit here and say she called him to her house, she gave a statement, it was voluntary, that's fine. As far as the way he paints the evidence, though, that's better made in closing statements after a trial, and that's not what we're here for. Mr. Dean, I tend to agree with the defense on this. Let's go straight into what the evidence is and proceed from there.
Oh boy, it looks to me like Leilani Simon is in big trouble. Let's bring in our guest and talk more about it. Criminal defense attorney Michael Riley on the program and criminal defense attorney and former prosecutor Matthew Mangino. Great to see you both on this Wednesday. Oh my, okay, let's talk about how concerned Leilani Simon should be over the death of her young son, Quentin Simon. This is just a horrific case. It's sickening, really upsetting. I want to get your both of your, kind of general thoughts on this case before we get specific. Mike Riley, would you start us off, please?
Sure. Thanks so much, Julie. I think Leilani Simon should be very concerned. The investigation is focused on her since the very beginning. She's reached out to the police. She's made several statements. She's made several statements that contradict themselves. She's now charged in the gruesome murder of young Quentin Simon, and the state seems to have quite a bit of evidence against her.
Yeah, they sure do, Mike. Her statements are a big problem, aren't they? Matthew Mangino, your thoughts, please.
Well, yeah, she does have some serious problems with this case. Primarily, she voluntarily called the police and got the police involved in this and then spoke to them without an attorney. And certainly you're not going to get an attorney if you're portraying yourself as a victim here, the mother of a victim. So, but her continuing to talk with the police after the initial contact is problematic. And, you know, what we're talking about here is a suppression motion. And what were any of these custodial interrogations, and that's the threshold. You have to be in custody and you have to be interrogated in order for a suppression motion to work. And that's what we're going to find out during the course of this hearing.
Exactly. Matthew, thank you for that. Was the cover-up worse than the crime? I mean, please don't misunderstand. We know that a child death, there's nothing worse. You know, a baby being killed. And the allegation is that he was assaulted with an unknown object before little Quentin was dumped in a landfill. The cover-up that happened after the fact, you know, to mislead police. Matthew, you touched on this, the making a false report. Mike Riley, do you think this almost makes it worse? Do you think these facts, the cover-up facts, might inflame this jury even more?
Absolutely, Julie. I think Leilani Simon only made things worse for herself by her efforts to cover things up, going to the media, making reports that Quentin's biological father may have abducted the child, all of these different statements trying to take herself out of it and suggest that she had nothing to do with it and that she was just a victim. I think that her statements don't add up, and a jury's going to see these statements and think, wow, she really was trying to hide something. And that's what we call consciousness of guilt. It suggests that she had something to hide, that she did something wrong. And that's not going to bode well for her at trial.
Not at all. Mike Riley, Matthew Mangino, thank you both for the insight. Stand by kindly, please. When we come back, prosecutors play the 911 call placed by baby Quentin's father the day that he went missing. We're going to hear this key piece of evidence together, and it includes a frantic Leilani Simon. That's next.
As a mom, I think that if this happened to me, knock on wood, I would hope that it wouldn't, I would come out and say something, you know, can y'all help me find my kids? You know, but you're not. You're going to Tabby and you're drinking and you're partying. Like, what are you doing? What is going on here? Where's the FBI? Where's Secret Service? Somebody needs to find this baby and lock her up. Lock them all up, because the grandma had custody. So if the grandma has custody and she left her with them, she's just as at fault.
We're talking about little baby Quentin Simon and bringing you Tuesday's pretrial hearing for his mother in what we're calling the landfill murder case. So the attorneys for defendant Leilani Simon presented a motion to suppress previous statements that she made. These were in the days and the weeks after her son's disappearance. She was interviewed numerous times by police, and at the heart of this case is the 911 call placed by her then boyfriend and little Quentin's father on the day that he went missing. This is a moment that was played in open court. Let's watch.
How did the police initially become involved in the disappearance of Quentin Simon?
So we received a 911 call on October 5th, and the call was made by Daniel Youngkin and Leilani Simon.
Okay. What time was that 911 call?
It was at 9:38.
And this was on the morning of October 5th, right?
It was.
And you said it was made by Daniel Youngkin and Leilani Simon?
Yes, they're both heard on the 911 call.
Okay. And what was the nature of the call?
It was mainly Daniel speaking, but basically he was saying that they could not find their 20-month-old son and that the front door was open. And
the defendant herself could be heard on portions of that call as well, is that right?
She can.
Okay. This has been introduced as State's Exhibit 1, Your Honor, and at this time I would ask to publish this to the court.
And you have tendered 1 through 32. Is there any objection to those exhibits coming in?
Not for limited purposes of this hearing, Judge, no. So I understand the court has to look at them and hear them and see them. But, so as far as this hearing, no, Your Honor, there's no objection.
It would be for the limited purpose of this hearing.
Right, of course.
All right. Thank you, Mr. Dean.
May we now publish State's Exhibit 1?
Yes.
38:37 seconds, October 5, 2022. empty. Yeah, I need to come to 535 Buckhalter Road, legally from kidnapped. 535 Buckhalter? Yeah. Did you say someone's been kidnapped? Yeah, we... I woke up and the front door is open and this place is empty, please. Your 1-year-old son? Yes! When was the last time you seen him? I saw him this morning when I left at 6. Okay, have you guys gone outside to check the area? Yes. How old is he? And he can't open the door. So you think someone broke in and the enemy sent any signs of breaking in? No. No breaking in, the door was open. Was it unlocked? Yeah, but the front door had bolts though, but yeah, it was. No, I can't find him nowhere. I was everywhere, and he's so scared, he's shouting everywhere. Okay, give me a description of him. Give me a description. He's, like he's got blue green eyes, tan skin, dark hair. He's what, ma'am? He's got tan skin, dark brown hair. His eyes are like a brown green hazel. Okay. And he's black, white, Hispanic. He's Hawaiian. He's what, ma'am? Hawaiian. Hawaiian? Yes.
You can stop. You can stop. I think we stopped the playback somewhere around 2 minutes now. Now, she could be heard on that call saying, I can't find my child, please. Right?
Yes.
So she, at least for that phone call, she wanted the police to come to her house.
Yes.
Sometime after that phone call, did patrol officers respond?
They did.
And did they make contact with the defendant?
Yes.
Where did they make contact with the defendant?
So on the back side of the house is the main driveway, which the family kind of uses as their front entrance area. So the family was waiting there.
Okay. If we could please publish State's Exhibit 2. This is an excerpt from some body-worn camera footage of responding officers.
Okay, without objection, please proceed.
Taylor, you can take Marine 3 off the board. He's got to fly out as soon as he's off today.
I woke up about 9 o'clock. The weather was worried about 6. So between the 3-hour period, somehow the front door is unlocked and my son is not in his playpen.
The 3-year-old son's there, the daughter's there.
But my 1-year-old
He can't get out of place by himself. He cannot. He can't even open doors. Yeah, I left for work at 6 o'clock. She called me at 9 o'clock. And the front door was open, like I said, he's gone.
I can't find him.
And she said about 2 weeks ago, she told us that she's seen a car sitting out front about 2 weeks ago.
You can stop it here.
Yeah.
So in this clip, we see that the defendant met the patrol officers in the driveway, right?
Yes.
In other words, she came to them.
Yes.
And they hardly had to ask her any kind of question at all. She just started talking.
Yes.
What'd you think of that call? What do you think of Leilani Simon? Stand by, my friends. We're going to hit a break. When we come back, we're going to see prosecutors introduce a series of recorded police interviews with the defendant after that frantic 911 call. After the break, she details the last time she saw her son, Quentin. We'll talk about it next. Welcome back to Court TV Live. I'm Julie Grant. Let's get you back into Tuesday's big hearing in the landfill murder case. The victim, little toddler Quentin Simon. Now, There was questioning of case detective Marion Lemons during this hearing. You're going to see her on the stand. And prosecutors, through her testimony, introduced a series of recorded interviews with defendant Leilani Simon, the child's mother. Now, this was conducted by a responding officer on the scene, and in the portion that we're about to watch together, Leilani Simon recalls the last time that she saw her 20-month-old son.
At some point, did detectives show up?
They did.
And who were the first detectives on scene for the Chatham County Police Department?
It was Detective Wilkins and Detective Melvin.
And did they interview some of the people that were on scene?
They did.
The defendant?
Yes.
Daniel Youngkin?
Yes.
And I think also Paul Simon, the brother?
I believe so.
Okay. Was that interview recorded?
Yes, it was.
How was it recorded?
So I think part of it was captured on the patrol officer's body cameras, and then the rest was on a handheld audio recording device.
Now, those interviews, I'll just note for the court, are included, that interview is included as State's Exhibit 3 in the exhibits that have been admitted. Now, did they ask her, did she tell them when she had gone to bed and when she had woken up?
Yes.
Okay. Could we please publish State's Exhibit 3 starting at 2 minutes and 10 seconds in? Or thereabouts. Yeah, that's fine.
Phone number. All right. Where's your fiance? That's him? I'll be with you in just a second, sir. I'm just going to ask you a few questions once I'm done with her, okay? All right. So when's the last time you saw your child?
When I went to bed last night.
And what time was that? Do you
It was
remember?
around 12.
12? Okay.
12 when I went to bed. I had my wisdom teeth removed yesterday.
I'm sorry. That's
So I went to bed kind of late.
I get you. Listen, I had them up too.
So I got up this morning about 9.
About 9?
And my front door is open, so I went up and I shut it, not thinking about anything like that. And I look over and check on my kids, and he was gone. All the rest were there. He was gone.
It's all right. It's all right. Take some deep breaths. I'll start asking.
We stopped the playback at 2:57. So she spoke to Detective Wilkins willingly, right?
She did.
He didn't have to force anything out of her?
No.
And she told him that she had gone to bed at midnight, is that
Yes.
right? Or around midnight?
Yes.
Okay. At some point, did officers on scene, well, let me ask you this. Did she have a car at this time?
She did.
What type of car?
It is a Dodge Journey.
At some point, did officers on scene become aware that that car had been out driving around at a period in the early morning hours of October 5th? It was after the time that she said she had gone to bed?
Yes.
Can you tell us how that played out?
So the initial officers, including the lieutenant, this time Lieutenant Foster, relayed information about what was going on at the scene, such as the vehicle's tag numbers. Those tag numbers were taken by one of the detectives still at the office, Detective Robbins, and she ran them in the flock camera system and saw that the vehicles were moving beyond what Miss Leilani initially said.
Specifically the Journey, right?
Yes.
What is the flock camera system? Just
Yeah, it's I believe it's like a neighborhood camera system. It basically will take a photograph of a vehicle's license plate as it passes by the camera, and it's stored for law enforcement to later look at.
And you can search it by tag?
We can.
Okay. Now, did that information get back to Foster that car had been out in the early morning hours of October 5th?
At this point in time, I'm going to object again. We seem to be getting far afield from a voluntariness question here more to evidence they wish to submit at trial. So I don't really see the relevance of any of this. I mean, again, I'll just lodge the objection again.
Mr. Dean.
Now, my very next question is going to be, did Lieutenant Foster go and talk to her about that?
Okay.
Did you ask her a question, and did she answer it?
Let's go there.
What does that look like? All of this bears directly on voluntariness.
Okay.
And I understand they're not trying to suppress that statement. I understand that. But the voluntariness of her statements that day, and to contextualize what brought her into the police department, and how she was receptive of police questioning. I do think it is important to look at what kicked this investigation off, and that she was answering questions willingly on scene and had in fact brought the police to her.
Okay, Mr. Hilliard.
Your Honor, when it comes to questions of voluntariness, the questions of voluntariness are simple. Was it a voluntary encounter between the police and the defendant? The context of that encounter is irrelevant. If the defendant is brought to that encounter in handcuffs or not free to leave, then it makes it a custodial encounter. Just that simple. We don't need to know what they had for lunch. We don't need to know whether or not their car worked. We don't need to know who lived in the house. We just need to know the context of that particular encounter between the police and the defendant.
Thank you. I'm going to sustain the objection.
All right, boy, listening to this is taking me back to law school and criminal procedure class. I remember my professor saying it very succinctly. Custody plus interrogation equals the need for Miranda, right? You know the warnings pursuant to Miranda versus Arizona, custody plus interrogation. You got to have those two things in order to trigger those warnings that are necessary. Let's talk a little bit more about what is needed, a knowing, intelligent, involuntary statement. What do we need in order to get that, to have the admissibility here? We have two great guests to talk about it with us. They both are practicing criminal defense attorneys in the private sector. We have attorney Michael Riley joining us and attorney Matthew Mangino, who also previously served as a district attorney in Pennsylvania. Great to see you both this morning. Okay, Matthew Mangino, I'd love to start with you, please. Kind of take us back to law school. Some of the things we're thinking about here as we analyze what Leilani Simon said and whether or not the court can consider it.
Well, Julie, you being a former prosecutor yourself, you hit the nail right on the head. I mean, what we're talking about here when we're dealing with issues of suppression of statements is, was the statement free and voluntary? Was the statement made during a custodial interrogation? And a custodial interrogation is one in which the defendant is not free to leave and is being interrogated, being asked potentially incriminating questions. So how do you determine if an interrogation is custodial? Was the defendant brought to the police station in a police car? Was the defendant or the suspect handcuffed? Were they not free to leave? Were they questioned by somebody wearing a police uniform with a badge and a gun? If it is that type of situation, then the police are responsible for giving those well-known Miranda rights. You have the right to remain silent. You have the right to an attorney. You have the right to, not to be interrogated without your attorney being present. And if that situation exists, that custodial interrogation exists, it's required that that defendant be Mirandized. If she isn't, those statements are subject to suppression.
Matthew, thank you kindly for that. Boy, excellent explanation right there. And so now let's take it a step further. Michael Riley, so knowing all of that, we've got the premise, we know what the law provides here. Do you think the defense team has a leg to stand on here in possibly getting some of this thrown out and not coming before the jury at the time Leilani Simon goes to trial?
Thanks, Julie. I do not think that they have a leg to stand on. We're looking at this Miranda inquiry. Was it a custodial interrogation? I agree with everything that's been said so far. There's also this question about voluntariness. Was this a voluntarily made statement by Leilani Simon? And as the prosecutor's pointing out in court, she calls the police. She essentially draws them in, brings them to her house, and gives them the story. And part of that story is that she went to bed at midnight, and they can show that she's lying about that because there's evidence to show that she was driving around after she told the police she was in bed. So I think that it's very clear that this statement was voluntarily made. And in fact, it sounds like it was made in an effort to cover up her involvement in the death of her son.
Exactly, Mike. False statements. She's got a real problem if the statements are coming in and if they're untrue. Very problematic, as you both know, for her as she heads to trial. May little Quentin Simon get justice? Mike Riley, Matthew Mangino, thank you both. Stand by, please. We're going to hit a break. When we come back, we're going to see the case detective outlining Leilani Simon's demeanor during those interviews after the disappearance of her baby, her child. She's charged with murdering her own child. And we're going to hear more of those revealing recordings when we come back.
We are underway in the trial of doomsday prophet Chad Daybell.
Prosecutors say they will seek the death penalty against him.
Investigators have recovered human remains at Chad Daybell's residence.
There's no way, Logan. I can never come up with this.
His wife, Lori Vallow Daybell, has already been convicted.
Now, will her husband end up with the same fate?
It's just so hard to know where the truth ends.
It's the doomsday prophet, Chad Daybell, on trial.
Welcome back to Court TV Live. I'm Julie Grant. We're talking about defendant Leilani Simon. This woman is accused of murdering her little baby, Quinton Simon. And there was a big pretrial hearing on Tuesday. In the portion of the hearing you're about to see next, prosecutors presented another recorded police interview with Leilani Simon after her 20-month-old baby was reported missing.
Now, all throughout this, the first interview, the second interview, talking to her about doing this written statement, what sort of tone are y'all thinking?
Very casual. At this point, we're just collecting as much information as possible, relaying it to every party that needs to know.
Was it at all accusatory?
Not at this point.
Was anybody raising voices or anything like that?
No.
The written statement itself was included at State's Exhibit 12. Now, after the three written statements were done, what did you all as the investigative team do with them?
So we all reviewed them as a team and spoke with some experts that the FBI had access to kind of discuss the next steps.
You were comparing them to each other?
Yes.
And I suppose with what the writer had actually said in interviews to that point?
Yes.
Okay. And while y'all were doing that, she was in the interview room with Officer Carlson, right?
I believe so.
And at some point when she was in there, she sort of opened up to Officer Carlson about some of her mental health issues. Is that right?
Yes.
And this was information that she essentially volunteered, correct?
It is.
And I won't, I suppose because of some of the objections that have been raised at this point, I won't publish that part. But let me just ask you this. It starts with her saying to Carlson something like, this whole thing will be easier if they come back in so I have someone to talk to.
Yes.
Something along those lines?
Yes.
And if you watch that, if the court watches it, the court will see that she would rather talk to you all than not.
Yes.
That's sort of the sense that you get from that utterance.
It is.
Sometime shortly thereafter, she got a visit from Danny in the interview room. Is that right?
Yes.
Okay. If we could please publish State's Exhibit 14.
Okay, so the last one was?
State's Exhibit 13, I have in the exhibit list as disclosure to Officer Samantha Carlson with the time at which that occurred.
Okay, so we're moving now to 14. Okay, you may proceed.
Yeah, cheeseburger and meat pie come your way.
That was Paul telling her at the beginning that she has food on the way?
I believe so.
Okay, good.
It's starting up there now.
I know.
It's still in the building.
I know.
The lady said I'm going to man.
All right, you can stop the playback at 46 seconds into that file. Okay, so she's not being held incommunicado or anything like that, right?
No.
Paula's talking to her from the hallway. Danny's coming in to see her. Talk about how you took her out for a cigarette.
Yes.
And sometime shortly after that visit from Danny, she showed herself out with a cigarette,
She
right?
does.
And asked Officer Carlson if she wanted to come with her or something along those lines?
Yes.
If we could publish State's Exhibit 15, please.
Okay, please proceed.
Do you have a jacket on you? I was talking about for you. So you maybe step out there with me while I smoke my cigarette. Is that freezing out there? It feels like somebody's.
So she wants to leave, she can leave, and she seems to know that.
Yes.
Sometime after that, you and Snyder interviewed her again in what I'm calling at State's Exhibit 16, CCPD Interview 3, right?
Yes.
And about how long was this one?
About an hour.
What were y'all talking to her about this time?
So at this point, we had confirmation that the child's father was at work during the time frame that we had. At this point, we wanted to have more conversations about this timeline and what could have happened.
Okay.
This is disgusting, isn't it? I mean, this case has just incensed so many people who were invested in bringing little Quentin Simon home when we heard of the disappearance, and then we later find out from police the little baby was put in a dumpster and then wound up in a landfill. And now his mom is going to be on trial for his murder very soon. Let's talk a little bit about these facts going before a jury and just how inflamed the members of the jury might be hearing all of this. Let's bring back in our guests, attorneys Matthew Mangino and Michael Riley on the program this morning. Matthew, let me go to you first here. Your thoughts on that, please.
Well, yeah, I mean, the whole scenario, obviously, it's a tragic death, a 20-month-old child. But these statements that are inconsistent that were made immediately after, which are indicative of a cover-up, which in itself is indicative of consciousness of guilt. These facts are going to be are going to weigh heavy on this jury and have a real impact on it.
Most definitely, Matthew. And then I'm wondering, might we see Leilani Simon try to get some kind of a plea deal from the state? Michael Riley, I'd love to ask you about that, please. Your thoughts?
I certainly think she should explore a plea deal, Julie. I think that these facts are really, really bad. Quentin was in a dumpster and then taken to a landfill. His remains found. These are ugly, ugly facts. And I think she should certainly explore the opportunity to take a deal and maybe have some hope of getting out of jail at some point in her life.
I think that would be great advice. I'm with you, Michael. Thank you for that. We've got to leave it there. Hopefully, little Quentin Simon gets justice. And let's remember, April is Child Abuse Awareness Month. I know both of my guests are certainly aware of that. We want to thank them for their time and insight this morning. Michael Riley, Matthew Mangino, always great to have you both on this program. We'll see you soon.
Just like Julie said earlier during that motion hearing, Leilani Simon is in deep, deep trouble. I mean, let me go ahead and make the understatement of the week. Leilani Simon is in hot water, and she wants to suppress the 911 calls and police interviews. Babe, what are the chances of me going to Vegas right now and hitting jackpot after jackpot compared to Leilani Simon? What'd you say? I got a better shot? I got a better shot than Leilani Simon walking free? Let me go ahead and buy my ticket then, because like these attorneys said, Leilani Simon's best shot right now would be to take a plea deal. Now, I'm not usually the one to advocate for any criminal defendant to take a plea deal, but this might be the first. The evidence is overwhelming. You talk about, it's like, as we say, as the young kids would say, it's like receipt on top of receipt on top of receipt on top of receipt on top of receipt. How are you going to dispute that? How are you going to defend that? You can't. Take the plea with the hopes that you'll get out of prison at some time. Don't take the plea deal and risk it all in court. Ladies and gentlemen, the lady outlaw is even telling her, "Don't do that." Let me run this back one more time, because this is what her options look like. Take the plea deal and have some hope of getting out of prison at some time. Don't take the plea deal and risk it all in court. The jury will find you guilty, and you will never, ever, 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 as Chris Tucker would say, see the light of day. That's all I got on that one. No, again, normally I'm not the one to advocate for a defendant taking a plea deal, but this one, yeah. Even my wife in the background, the lady outlaw, she's telling Leilani Simon, take the deal if it's offered. Next up, ladies and gentlemen, I got one filed under justice served. And this one makes my New York heart feel so good. This one makes my New York heart feel so good. And this is only going to take a quick minute, but it'll be the satisfying minute I'll ever get to broadcast. Check this out.
I want to update you on a story here. A New York man was sentenced to 47 years to life for kidnapping and sexually assaulting a 9-year-old girl who went missing from an upstate New York park last year. You remember this case. In February, Craig Ross pleaded guilty to taking a girl from a campground on September 30th. The little girl was on her bike and was headed back to her family's campground after taking a last lap. However, she didn't return. Her disappearance sparked a 2-day search before she was found alive, hiding in a cabinet inside a camper on Ross's mother's property. Now, the break in the case came when law enforcement guarding the girl's home saw someone put a ransom note in their mailbox. Police were able to match fingerprints on the note to Ross. Now, Ross was sentenced to a minimum of 25 years to life in prison for the kidnapping charge and 22 years to life for predatory sexual assault of a child. His sentences will be served consecutively.
Ooh, like I said, that did my New York heart so good. Craig Ross deserves every last bit of this one. You're going to kidnap a child. You're going to SA her, and then you decide you want to stretch this out with a ransom note? Seriously? Okay. Let me go to my background now. Lady Outlaw, you know the saying, play stupid games. And that's exactly what Craig Ross won. 47 years to life. Craig, congratulations. You win the stupid prize of the week thus far. Justice served. Enjoy your time. Next up, update in the Bryan Kohberger case. You know what? I'm laughing right now because we got another. He's got an alibi. Bryan Kohberger has an alibi, and even this one I have to laugh at because it's not really an alibi. If you don't believe me, wait till a little bit later because Julie Grant has a lot to say about that one. Accused quadruple murderer Bryan Kohberger maintains he was out driving the night 4 University of Idaho students were killed. Kohberger, through his attorneys, submitted his alibi Wednesday. That's according to a previous court order, gave the defense until an April 17 deadline to submit that alibi. April 17th has just passed. Let's go to Ted Rollins for an update on this case. Ted.
Let's talk about that other big case out of Idaho, and we have new information in the case against Bryan Kohberger. Yesterday was the deadline for Kohberger's legal team to provide the court with documents relating to an alibi for the 2022 University of Idaho murders. Take a listen to how it played out in court.
I'm confused because if the defendant alibi is that he was out driving around that night, I'm not sure what additional information his cell did add to an actual alibi defense. It seems like what the defense is asking for, and they're being completely upfront about it, and I appreciate that, but what they're asking to do is essentially double check all the discovery before disclosing their alibi, and that's not what the purpose of an alibi deadline is. In fact, it's quite the opposite.
That was that was the court appearance back in February, setting up the deadline, which was yesterday. And basically the deadline from the judge was like, all right, alibi, don't just willy-nilly say he was out driving around. What's your real alibi? And so they filed it, and it's kind of the same alibi. He's out willy-nilly driving around. But they say that they have they have an expert that's going to prove that he was out driving around nowhere near the murders. Here's what it says. Mr. Kohberger was out driving in the early morning hours of November 13th, 2022. They go on to say that the cell phone data will show that Bryan Kohberger's mobile device was south of Pullman, Washington, and west of Moscow, Idaho, on November 13th, 2022, and did not travel east in the early morning hours of November 13th, and thus could not be Kohberger's, be the vehicle captured on video along the Moscow Pullman Highway near Floyd's Cannabis Shop. So, what does this mean? Let's bring in Josh Schiffer. They're attacking, Josh, the cell phone data and the information that the prosecution has with the cell phones, and using it. Now they're trying to use it as an advantage. That's just one piece of the puzzle.
It's one piece of the puzzle, and I'm kind of flummoxed because as an alibi, traditionally an alibi really tends to be detailed. I was with this person at this point and therefore could not be, and there's corroboration involved. Here, it rather than those specific details, it's much more of, we're going to be able to use some technology to corroborate an excuse for why he couldn't have been there or shouldn't have been there. But that excuse is not really specific. It's driving around. Where? Well, kind of over there. And then there's the issue of the fact that the phone was turned off.
During the murders.
Exactly. At the time of the murder, that's really kind of inconvenient. But what it does function as, by filing an alibi, when you get to death penalty cases, the litigation dynamic changes dramatically. There's the defense of, I'm looking for exculpatory and an acquittal, but then the other defense is, I'll do anything to keep a needle out of me. And this functions much better on anything to keep a needle out of me than an acquittal, because it will inject enough reasonable doubt.
Saying they just, if they're, you're saying a win is get rid of the death penalty if they can get there. More of this part of the equation here, the defense alibi response says that the defendant is an avid runner and hiker. He explored many areas. After the school year began, Mr. Kohlberger was busy with classes and work at Washington State University, and his running and hiking decreased, but did not stop. Instead, he did it at night. His nighttime drives increased. This is supported by the data from Mr. Kohlberger's phone, showing him in the countryside late at night and or in the early morning on several occasions.
I'm gonna laugh a bit. And the reason I'm gonna laugh a bit is because of what you're going to hear next from Court TV's very own Julie Grant. This was her opening statement earlier in the week on Kohlberger's alibi, if you want to call it that.
Why don't you go ahead and grab that cup of coffee, because it's time for my opening statement. It's not an alibi. Stargazing by yourself is not an alibi. Brian Kohlberger, the man accused of murdering those 4 beautiful University of Idaho students, is saying that his alibi is driving around in his car in the middle of the night and gazing at the stars.
I paused just long enough to laugh. I mean, right at the beginning, she said it. Stargazing isn't an alibi. I mean, which one of the stars you want to call as a witness? Oh, that's right, you can't. Thank you, but please, Prosecutor Julie Grant, continue.
Number 1, that's not an alibi. Number 2, give me a break. The word alibi means elsewhere in Latin. That's where it's derived from in the law. And an alibi defense in a court of law is proof that I was somewhere else. And with this proof, you can see that there is an impossibility of me being at the crime scene. It's most often done by calling witnesses. So what's Kohlberger gonna do? Is he gonna subpoena the night stars? Sure. He has some supportive cell phone data showing that he was traveling around other places besides that house on King Road where those beautiful students were slaughtered. But his phone was powered off during the time that police say the homicides were committed. Imagine that. And my question is, if his phone is off while he's stargazing, how's he going to take those pictures of the stars with his phone that he likes to take? His lawyers also say he was driving around alone at nighttime, and that was his habit. A habit that involved driving near the homicide house 12 times before those angels were killed. Sounds more like stalking to me. Quite frankly, his alibi defense is absurd. It doesn't show he couldn't have possibly committed the murders. All it shows me is that this guy is a real creep. A creep who deserves to pay dearly if he took the lives of Kaylee Gonsalves, Madison Mogan, Xana Kernodle, and Ethan Chapin. That's my opening statement on this Friday morning. Let me know if you like it. Right.
I would have saved that that statement for just a little bit later, because I'm usually closing these editions of Bethea'S Byte Reloaded with her opening statements. But that one had to be shown right then because of, one, how foolish that alibi sounds. And two, I needed somewhat of an expert to say that's not an alibi. And who better than a former prosecutor? Kohlberger? You better come up with something fast. You better come up with something better than that, because right now, just like with Leilani Simon, your butt's in the fire. You're in deep, deep trouble. Okay, let's see what I got here. Next, I did the God's Misfits thing. The 5-year-old malnourished girl, her old deceased mom, boyfriend, and grandma charged. Oh! Hold on a second. We got one I can file under justice served again. Hang on tight, guys. This is the sentencing in the case of the state of Tennessee versus Robin Howington. The mother-daughter murder trial. Talk about a face only a mother would love. But I digress.
Ms. Howington was convicted in docket number 117659 in count 1 of the lesser included offense of reckless homicide. It's a Class D felony. Does everyone agree she is a range 1 offender?
Yes, Your Honor.
Judge, I did file a sentencing memorandum, which I argue especially mitigated.
I understand, but I mean, she doesn't have any range enhancement convictions.
Mike, I didn't get a copy of that. I apologize. I don't have a copy of Mr. Whalen's sentencing memorandum. Is there a way that I can get a copy from the court's file? I think it was filed yesterday.
You can have my copy. I've already read it. All right, so she's 2 to 4 unless the court were to find she's an especially mitigated offender. In counts 2 and 3, she was charged and convicted of aggravated child neglect, a felony. Which count was the serious bodily injury count? Which count was the weapon count?
I believe 2 was the serious bodily injury, 3 was the weapon.
All right, so she's 15 to 25 on each of those unless the court were to find she was an especially mitigated offender. Where are the other notations? She was found guilty in count 5, tampering with evidence, a C felony, 3 to 6. Count 6, attempted tampering with evidence, D felony. Thank you. D felony, 2 to 4. Was there not a false report conviction as well? Yes, count 4 is false report. D, felony 2 to 4. All right, does either side have, other than victim impact, additional testimony that the state or Ms. Hallington wishes for the court to consider before the imposition of judgment in this case?
Your Honor, no testimony from the state. I would like to introduce the PSI as Exhibit 1.
All right, mark the pre-sentence investigation report as Exhibit 1.
And then, Your Honor, Antoine Oliver has provided me with a few pictures of the victim that he would just also like the court to see the victim before she died.
I mark those collectively as Exhibit 2. Mr. Whalen, any exhibits?
No, Your Honor.
All right, let me hear the state's position. Let's start first with enhancement factors the state believes are applicable to each of the various counts of conviction.
Yes, Your Honor. So the first one that we would ask the court to consider is that the defendant has a history of criminal convictions or criminal behavior. As noted,
Assuming you're urging that that applies to each of the 6 counts. Counts 2 and 3 merge. Which count is, I'm assuming the state has to count 2 to be the one that stands, correct?
yes, Your Honor.
All right. So, previous history of criminal convictions or behavior.
Yes, Your Honor.
1 versus finding 5. That's not what the law says. Ms. Hallington, this is a strange case. This is one of the more unusual cases among the hundreds that I've tried as a lawyer or as a judge. But there are a couple of things in this case that are just glaringly obvious. I agree with what General Good just said a few minutes ago. You are not the victim in this case. You have a previous history of criminal convictions or criminal behavior. What you had before the night that this tragedy occurred was not very significant, although you were engaged in the trafficking of illicit narcotics, and the court can consider that. But I really don't know how you could have made this much worse than what you did that night. Within literally minutes of when your daughter had been shot and killed, you were attempting to hide the firearm that was used to kill her. You're not concerned, you weren't then, you're not now. You're not concerned with trying to protect Gavin. You're concerned with trying to protect Gavin's mother. And you have been, you were that night, and I will believe that from this point forward. I don't know how you could interpret this evidence any other way. You have a previous history of criminal conviction, criminal behavior. You tried to hide the gun that was used to kill your daughter while her body was still warm. When you were taken to UT Hospital to be checked for shock before you spoke with law enforcement, you attempted to solicit another person to take your cell phone so that it couldn't be looked at, and then you tried to destroy the cell phone. Within seconds, if not minutes, of when your daughter was shot and killed, you're calling 911 and making up a story about how it all happened. And repetitively, I quit counting at about 20, repetitively throughout hours worth of police interviews, not just that night, but on other occasions as well, you made up story after story after story. And this court can consider every bit of that as criminal conduct. So you clearly have a previous history of criminal convictions or criminal behavior which enhances your sentence in this case. As to count 2, the aggravated child neglect where there was serious bodily injury, count enhancement factor number 9 applies as well. A firearm and your handling of that firearm is the reason that your daughter is not here now. It's not because Antoine Oliver showed up 2 days earlier. It strains the bounds of credulity to believe that your boyfriend just laid that gun down where a small toddler could just walk in within 2 or 3 minutes after you and your children arrived home, found the gun, pointed it at your daughter, and pulled the trigger when that gun had been in that same place for 24 to 36 hours and nobody saw it. I will never believe that. And I don't think you were honest with the jury about how that happened. But the simple fact remains that however he found it, you were responsible for that gun. What I believe happened, if in fact it was your child that had the gun, when the bullet was fired that killed your daughter, there was a man that came in. And I don't know if it really was somebody to collect window tint payments like you testified to, or if it was a pill deal, but somebody came in. It was a strange man in your house, and I believe you had that gun out for protection. I believe you had a round chambered and the safety off, and that gun was left there, and when you stepped out to smoke, the tragedy occurred. But that's on you and nobody else. So I place great significance on the two enhancement factors that I found. Your history as well as the firearm use in this case. As stated previously, the mitigating factors, this was an unusual case. There are unusual circumstances, but I don't place much weight on that as far as mitigating your punishment. So if you would, please, ma'am, stand up. Ms. Allington, in docket number 117659, based upon the jury's verdict of guilt, finding you guilty in count one of the lesser included offense of reckless homicide, you were found guilty of that offense and sentenced to a term of 3 years to serve within the Tennessee Department of Correction as a range one offender. In count two, based upon the jury's verdict of guilt, finding you guilty of aggravated child neglect, you were found guilty of that offense and sentenced to a term of 22 years to serve within the Tennessee Department of Correction as a range one offender. In count four, based upon the jury's verdict of guilt, finding you guilty of false report, a Class D felony, you were found guilty of that offense and sentenced to a term of 3 years to serve within the Tennessee Department of Correction as a range one offender. In count five, based upon the jury's verdict of guilt, finding you guilty of tampering with evidence, a Class C felony, you were found guilty of that offense and sentenced to a term of 5 years to serve within the Tennessee Department of Correction as a range one offender. And finally, in count six, based upon the jury's verdict of guilt, finding you guilty of attempted tampering with evidence, a Class D felony, you were sentenced to a term of 3 years to serve within the Tennessee Department of Correction as a range one offender. These sentences will be served concurrently, one with the other, for a total aggregate sentence of 22 years to serve within the Tennessee Department of Correction. And as your attorney has pointed out, the service rate is at 85%. I wish we weren't here. I know that you wish you weren't here. Mr. Oliver wishes that we weren't here, but you're the one responsible. That'll be the judgment of the court. Good luck to you. When do we need to set this for motion for new trial?
Judge, we'll need a transcript. I suspect that's going to take.
"22 years. Robin Howington convicted on the charges of reckless homicide in the September 2019 death of Destiny Oliver, her daughter. At the sentencing, the judge said he quit counting how many lies Howington told in the aftermath of her daughter's shooting. She was ordered to serve her sentences for 6 charges concurrently, equating to 22 years in prison. Ladies and gentlemen, this is what happens when you commit a crime and then try to cover it up. 22 years behind bars. Justice served. Next up, I have an update on a 12-year-old boy who vanished in 2020. All right. The body of a 12-year-old boy who vanished in 2020 was found in an attic last week in Buffalo. Jalen Griffin disappeared on August 4th, 2020 while walking his dog. His body was found April 12th in the attic of a 4-unit apartment roughly 5 miles from where he was last seen. That's according to Buffalo Police Commissioner Joseph Gramaglia. He called the discovery an absolute tragedy. 3 months after Jalen vanished, his 18-year-old brother was shot and killed across the street from his family's home. Griffin's mother unexpectedly died last year, never knowing what happened to her son. The family advocate Karima Morris told Scripps News Buffalo, "I think she died of a broken heart." Which scientifically, yes, that can happen. According to Erie County records obtained by Scripps News Buffalo, the home where Griffin's body was found is owned by Sunrise West LLC in an active lawsuit filed in 2022. A neighbor claims that a tenant of the unit threw pieces of burnt mattress out the window, causing more than $130,000 of damage to the neighbor's home. Sunrise West LLC and Spectrum Health and Human Services are also being sued in that lawsuit. The neighbor and their attorney claim Spectrum Health and Human Services was negligent, careless, and/or reckless in vetting tenants for the apartment home. According to Spectrum Health and Human Services website, the organization has a supportive adult housing program that caters to high-need, high-risk individuals with co-occurring mental illness and substance abuse issues. Spectrum Health and Human Services would not comment if the home was ever utilized by Spectrum. However, a spokesperson did say they are cooperating with police in the homicide investigation of Griffin. Multiple neighbors told Scripps News Buffalo there have been issues stemming from the home for years. That's a shame that now we'll never. It's basically a case of we'll never know exactly what happened to Jalen Griffin, and that is sad. Next, Gypsy Rose. Gypsy Rose Blanchard is filing for divorce from her husband and filing a restraining order against him. 3 months after moving in with her new husband, Gypsy Rose Blanchard has formally filed for divorce and moved in with her parents. Court TV obtained a copy of the divorce petition filed by Gypsy Rose, who had legally changed her last name after marrying Ryan Anderson. The two married while Gypsy Rose was serving time in prison for murdering her mother. She was released after serving less than 10 years on December 28, 2023. The divorce petition lists the couple's wedding date as July 21st of 2022 and says they were married in Livingston County, Missouri, which is where the Chillicothe Correctional Center is located. While the two lived together after her release, the filing says that the couple separated March 25th and have lived apart since then. Gypsy Rose posted an announcement about the split to her private Facebook page, saying that she had decided to move in with her parents. In her filing, Gypsy Rose says that the couple has no children, that she is not pregnant, and requests the court order Ryan to pay her spousal support because the petitioner is in need and the defendant has an ability to pay, and she is not at fault in the dissolution of the marriage. The petition further states that Ryan is not entitled to final spousal support as he is at fault in the dissolution of the marriage, but offers no further detail about the reasons for the split. Gypsy Rose requested a restraining order in her filing, which the court granted. The restraining order does not suggest any physical violence, but rather is focused on the couple's financials and prohibits either party from hiding or disposing of assets before the case is settled. It's unclear what assets the couple may have. Before her release from prison, Gypsy Rose wrote a memoir which she self-published upon her release, Conversations on the Eve of Freedom, and was the focus of the Lifetime docuseries, The Prison Confessions of Gypsy Rose Blanchard. Despite joining social media and posting prolifically immediately after her release, Gypsy Rose deleted all of her public social media accounts before filing for divorce. People has reported she has been seen recently with her ex-fiancé, with whom she got matching tattoos. Well, as far as her former criminal case, I have some sympathy. Oh, what's good, Combat Vet? How you been? Good to see you, man. I had some sympathy for what Gypsy Rose is going through. Not total, but some. Now I just hope that whatever comes her way next, she'll make good decisions, and it'll serve her well. That's all I can do is wish her the best of luck. Next up, suspects in the Jared Brydgen murder case are still fighting to get the prosecution off the case. Ooh, this is gonna be a long one. I don't have that kind of time. I'll just go with this article. A Florida judge will take nearly 2 weeks to decide whether to disqualify the assigned prosecutor and the entire Duval County State Attorney's Office from trying a murder case. Mario Fernando Saldana and his wife Shauna Gardner are accused of killing Gardner's ex-husband, Microsoft executive Jared Brydgen, in a murder-for-hire plot in 2022. Both Saldana and Gardner face a potential death sentence if they're convicted of the murder, after their alleged gunman, Henry Tenon, pled guilty and agreed to cooperate with prosecutors. While the couple is being charged together, they have requested separate pretrial hearings. And at 2 hearings this week, their attorneys argued that the prosecutor's office should be disqualified from working on the case after allegedly accessing private communications. Saldana's defense argued that there was an agreement in place with the prosecution that a third party would review all the data collected from the defendant's emails and phones to ensure that no privileged communication with their attorneys was inadvertently included in the evidence with discovery. But Saldana's attorney, Jesse Dracer, said in court on Thursday that prosecutors were chomping at the bit to get into the data and refused to wait, and in doing so got access to a series of documents they never should have seen. I'm stopping reading that article there, saying if it's that serious, what do you gotta hide if you're the defense? The article goes on to say the prosecutors argue nothing inappropriate was accessed. Part of the argument the defense put forth was that the emails and text in question had subject lines including the word confidential. Prosecutors argued that there is no confidentiality in services like Google or Apple, which comply with subpoenas regularly. At one point, prosecutor Adam Mizrahi argued to the judge, you can't send evidence to your lawyer and then claim privilege. Which I agree. One of the attorneys representing Saldana took the stand during Thursday's hearing, and when challenged by the prosecutor about the level of encryption in their email system, responded, we never had issues with our emails like we've had in this case. Saldana's attorneys noted that they plan to file a public records request asking for all email and text message exchange in the prosecutor's office related to this case that may have discussed the documents in question. On Friday at Gardner's hearing, her attorneys argued similar points, but also argued that similarly placed marital communications between the couple had been accessed as well. Prosecutors have accused the couple of having Brydgen murdered amid a custody dispute and said in documents that Brydgen had emailed Gardner 2 weeks before his death saying he planned to have one of their children baptized in the Mormon church. So we'll find out exactly what happens with these two, and that and the challenge to having the prosecution thrown off the case in the next couple of weeks. Now an update to another tragic story. More remains found that believed to be Sade Robinson.
$600 gonna pay. This is justice for Sade. Who the would do something like this to my beautiful baby? She hurt nobody.
Welcome back to Court TV Live. I'm Michael Ayala, turning now to Wisconsin, where we are still following the tragic story of the murder of Sade Robinson. Now, last week, authorities arrested and charged suspect Maxwell Anderson in the death of that missing 19-year-old. They say Robinson went on a first date with him on April 1st, the night that she went missing. Her car was found torched and fragments of human remains were found, including a leg. Now, these remains were later confirmed to belong to Robinson. And yesterday, someone walking along Lake Michigan in South Milwaukee found a torso and an arm. Well, investigators believe these could belong to Robinson as well. Megan Lee, the Scripps News Milwaukee, brings us the latest.
You can still see footprints all over this remote beach that's along Lake Michigan here in South Milwaukee. Neighbors tell me investigators were out here for much of the morning on Thursday. This home security camera footage shows investigators by the Milwaukee County Medical Examiner's van just up the hill from the beach. It's yards from my front door. Someone walking the remote beach around 7:30 this morning found a torso and an arm just yards away from Angela Buchanan's home.
I'm definitely on edge now.
The Milwaukee County Sheriff's Office believes the body parts belong to 19-year-old Sade Robinson.
This is not something that anybody should have to go through, especially such a young girl.
Angela was just out on the beach the evening before walking her dog.
It just kind of makes me scared now to kind of want to come down here with my dog, and do what we do every day, because now it's, am I gonna come down here and be the next one that's gonna find more body parts?
Angela's neighbor Gail, who didn't want to be on camera, says the beach is her escape. Is this disturbing to you?
Honey, the whole world is disturbing right now.
With tears in her eyes, Gail can't help but think about Sade's life that was cut too short.
Oh my God, my heart breaks for her. If I would have found those, I would have been devastated. I can't even imagine what their family feels like. My heart's gonna cry for this. I can't. It's gotta stop.
Something that won't stop is the search for Sade's body. Gail joined the family and friends along the shoreline Thursday afternoon. Investigators say they were taking a sonar boat out on the lake to look for more body parts on Friday. In South Milwaukee, Megan Lee, TMJ4 News.
The article goes on to say that MCSO investigators believe the 19-year-old was murdered by 33-year-old Maxwell Anderson around April 2nd. Anderson's been charged with first-degree homicide, mutilating a corpse, and arson of property other than a vehicle, because he's accused of burning Robinson's car. He was arrested April 4th, 2 days after the leg was found by a passerby down a bluff at Warnemont Park in Cudahy. The leg had been severed just below the hip. The torso and arm found Thursday morning were spotted along a remote stretch of tree-lined beach on Lake Michigan. Investigators say they were nearly a quarter mile from an apartment complex. Yes, like I said, it's a tragic case, but hopefully we'll have more information, and it might tie Anderson to this young lady's murder. we're finally at the end of this edition of Bethea'S Byte Reloaded. But before I get out of here, I've got not one but two more opening statements from Julie Grant. First, this is in regard to the case I was just talking about. Julie, and I know a lot of others, myself included, are demanding justice for 19-year-old Sade Robinson.
On April 1st, her life was cut tragically short in the most unthinkable way. Police say Sade Robinson was murdered, her body dismembered, and her car set on fire. All this after a first date, a dinner together at a seafood restaurant. Beautiful Sade Robinson never made it back home. Police say that they have their suspect behind bars, the man who went on that date with Sade. His name is Maxwell Anderson. And if what police say he did is true, this guy is a monster from down below. And if he killed her and dismembered her body, may he pay dearly for the crimes with the harshest penalties the law allows. You know, this morning, my friends, I'm thinking about how this case is still being investigated, and much of Sade Robinson's remains are sadly still missing this morning. I can't even begin to imagine the heartbreak and the agony that her family is going through right now. This is just the beginning of the criminal case, but it's also just the beginning of a lifetime of pain for her family. May they find some comfort in knowing that people all around the world are sending them love and light, honoring and remembering their beloved Sade. May she get justice, and may she rest in peace.
I couldn't have said that any better. I really could not have said that any better than that. And that is what anybody with a heart that is just finding out about this case or has followed this thing from the beginning, all we are demanding is justice for Sade Robinson. And now from that case to Julie's statement on an unsung hero in another high-profile case. Julie Grant gives a little bit of a tribute to Charles Vallow. Whoops, I hit the wrong one. Hang on, guys. Yeah, I hit the wrong. I dropped the wrong link in. There we go.
Just listened to Charles Vallow This show is all about getting you primed and ready for the court day ahead, just like the actual opening statements do at a trial. We cover the major cases we're broadcasting on Court TV Live, and we do deep dives into the big cases making headlines in true crime. I say it's like coffee in court, my friends, because it's morning time. We get warmed up together. We have a fantastic show ready to go for you. So right now, go ahead and grab that cup of coffee because it's time for my opening statement. If someone would have just listened to Charles Vallow, perhaps JJ, Tylee, and Tammy would still be alive today. What a good man he was. Charles Vallow was kind, loving, smart, talented, a devoted father and husband. He was so smart, he figured out the criminal conspiracy long before investigators ever did. And he was brave too. He confronted them all and called them all out. He was trying to warn Tammy Daybell about the affair. He confronted Chad and Lori directly. What a good, honest man. You know, he's Kay Woodcock's brother. What a lovely woman she is, right? So of course he's a wonderful soul just like her. They are great people who were victimized terribly by people who seem to me to have no soul. The criminal conspirators operated under the guise of religion. I can't stand that. They operated under the guise of religion to do the unthinkable. Criminal conspirators carrying out 4 murders: JJ, Tylee, Tammy, and Charles Vallow. Charles Vallow died trying to protect those children. He knew Lori had become dangerous, and he was in fear of his life. He tried to warn everybody. He told police how she threatened to kill him and promised that nobody would care. Oh no. No. We care. All of us in places all over the world care about what happened to Charles Vallow, and to JJ Vallow, and to Tylee Ryan, and to Tammy Daybell. Charles Vallow's 2 sons deserve to have their father here with them today. His sister Kay and his brother-in-law Larry deserve to have him here today. Charles Vallow may be gone, but he is certainly not forgotten. He will be remembered dying trying to protect the 3 people that Chad Daybell's homicide case is all about: JJ, Tylee, and Tammy. And if only someone would have listened to him. That's my...
If only somebody had listened, indeed. Now maybe someone will listen to him from the grave. And maybe that'll be the difference. That could finish Chad Daybell once and for all. Charles Vallow, as I said at the beginning, an unsung hero in this case. That's going to do it for Bethea'S Byte Reloaded. I want to thank everybody for watching. I want to thank everybody who just showed up and checked. Combat Vet, again, great to see you. If somehow, some way you caught this and you enjoyed this live stream, and you want to make a contribution to it, just to keep for the upkeep, I've got 3 ways you can do this. You can drop me a little something at PayPal, EKB316, Cash App, $ EKB316, or Venmo, EB the Last Outlaw. But like I said, and I say this with the same honor and integrity as my good friend, allegedly with Brittany J. Shout out to her. Nothing is obligated, but always appreciated. Let's see what I got in my chat real quick. Combat vet. Always good to see you, my friend. Always good to see you too. All right. I don't have it flashing on for chat for this live stream, but you can still get in contact with me on Facebook at Bethea'S Byte Reloaded, on X, formerly known as Twitter, at capital EKB316. Here on YouTube at Bethea'S Byte Reloaded. On Instagram at lowercase EKB316. On TikTok at King of Hearts 316 2021. Or you can email me, kingofhearts316_09 at outlook.com. I look forward to hearing from you. I look forward to doing this again. And we may start a special time next week, but I look forward to doing this with you guys again and again and again and again as I report the stories that we're covering. I report the stories nobody's covering. Need to be live more often. If only I could do that. If I could do it full time. I'm like Brittany. But I'm not at that point yet. But keep praying for me that I can do this at some point like that. But still, like I said, as long as we can keep this thing going onward and onward and onward and onward, we can grow this community bigger than what it already is. And to the growth that we have already, I say to each and every one of you, thank you, thank you, thank you. I say this all the time. It's you guys that make Bethea'S Byte Reloaded and run as smooth as it does. Alright, so right now I'm going to get out of here. And again, thank you all for joining me. Thank you all for catching the replay. I look forward to doing this again next week. I'm Ernest Bethea, the Last Outlaw. This is the drama-free true crime destination. This is Bethea'S Byte Reloaded, and I hope to see you again next week. Until then, you all know what to do. Bite this. Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe, and drop me a comment on this video. And be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.